Morena, and welcome to Thursday, 9th of February, for the continuation of these hearings in relation to integrated management and other issues. We really, just before I start, I do need to, most of you have probably been through this, so bear with me, but I'm told I've got to do evacuation and emergency procedures, so I'll just quickly mention the fact that if we have any emergency, you exit through the doors to the rear, all toilet facilities, etc., are outside in the same direction. The rally point is outside the Spates Ale House, which is that magnificent building up the road. Please stand there until the fire wardens completed their reconciliation duties. I'm told I'm also to say if there's an earthquake, take shelter under any close by desk, which we have to do in Marlborough from time to time, but hopefully not down here. Otherwise, can I just ask that everybody make sure their cell phones are turned off, and we will commence with Dr. Summerlin and your witness.
Yes, Kia ora. Thank you very much, Commissioner. I have one witness, Mr. Andrew Burt. He's now locked in, so he's online. And he has the principal statement and one supplementary statement and update. Can I just ask, the panel, has the panel read through his evidence, or that's marvellous. Well, I might just get him to refer to a summary then, if that is suitable, acceptable. So perhaps if we could.
Once he starts speaking, he'll come.
I see. All right, Mr. Burt, you can hear me all right?
Yes, I can.
Right. Thank you. I just wish to confirm that your full name is Andrew Neil Burt. You're employed by Beef and Lamb New Zealand Limited as Chief Economist, and your qualifications are set out in your principal evidence. Is that correct?
Correct.
Mr. Burt, or Andrew, I wonder if you'd be kind enough to refer to your brief supplementary statement and read that, please, from paragraph 4.
Certainly, Dr. Summerlin. Good morning, everyone. First, just a minor typo at paragraph 2 at the end there. It says 23 November 2023. We got a bit ahead of myself there, so that should be 2022. From paragraph 4, I've been asked to give an update on the progress of the Economic Work Programme, which was initiated by the Otago Regional Council in the second half of 2021 to form a better understanding of the use of freshwater in Otago's economy. The primary driver for the work was the need for Otago Regional Council to develop the Land and Water Regional Plan to implement the National Policy Statement for freshwater management in the region. Beyond the Land and Water Regional Plan, the work was part of a longer-term move for ORC to build capability and understanding around the use of fresh water in different sectors of the economy, its sustainability, and the well-being of people and communities to inform future policy processes. To date, I've been involved in the first of the 5 projects within the Economic Work Programme, which produced a report called Farmers and Growers in Otago. The purpose of the report is to characterise farming and growing in Otago to improve the general understanding of these topics ahead of development of the new Land and Water Regional Plan. The report was developed by ORC's Industry Advisory Group, which is made up of key rural sector groups, including Foundation for Arable Research, FAR, Horticulture New Zealand, Deer Industry in New Zealand, Beef and Lamb New Zealand, Dairy NZ, and the Central Otago Wine Growers Association, along with the Ministry for Primary Industries, MPI. The Farmers and Growers in Otago report brings together information on farming and growing practices across Otago, spanning at least 150 years. This work draws on research completed in Otago for MPI's Farm Monitoring Program, which was a national effort in cooperation with industry groups from across the agricultural sector. The main body of the report is divided into 6 chapters. A, sheep and beef cattle farming. B, deer farming. C, arable farming. D, dairy farming. E, horticulture. And F, viticulture. These chapters are specific to each industry, however, generally cover a historical view, size and distribution, main features, and important connections with processing facilities and markets.
Thank you,
I'm
Mr.
happy to answer any questions.
Just before you do, can you return to your principal evidence at your summary section at paragraph 9 and read from 9 to 22?
Certainly. Sheep and beef farming in Otago is conducted in diverse and complex environments. This is, from our perspective, reflected in the average area of different classes of farm. On average, South Island high country farms are over 20 times the area of South Island finishing farms in the region. Overall, an average of about 85% of a farm's total area is used for grazing. The other 15% provides non-farming services, such as native vegetation cover. There is a significant amount of carbon sequestering woody vegetation on sheep and beef land, covering approximately 2 million hectares, or just under 20% of all sheep and beef land area. The majority of New Zealand's covenants that protect land in perpetuity under the QE2 National Trust are on sheep and beef farms. New Zealand sheep and beef have carbon footprints that are among the lowest in the world. The average stocking rate for sheep and beef farms in Otago remained almost unchanged between 1991 and 2021, when the weighted average stocking rate was 4.1 stock units per hectare of grazed area, which is equivalent to 1/2 of one Frisian dairy cow per hectare. While there was some conversion of better land to dairying, most farms continued to be farmed with the natural capital of the properties and long-term sustainability, economic, environmental, and social sustainability in mind. Dairy grazing revenue averages less than 1% of total gross farm revenue in Otago. Sheep dominate the region, as is widely known intuitively. The number of sheep decreased by 40% between 1991 and 2021-22. The number of beef cattle increased by 40%. The number of dairy cows increased by over 80% from a very low base. The number of stock units overall decreased by nearly 9%. The application of elemental nitrogen, phosphorus, potassium, and sulfur is low. Nutrient losses are low, with other evidence, particularly that of Dr. Jane Crystal, addressing this point in more detail.
You answer your questions.
Thank you, Dr. Cole.
Thank you. I'm not sure, Dr. Bird, if you've been listening to our conversations around some of the IEM provisions, in particular IEM P1 and P2, which is where some of those decision-making priorities are listed. But what I took from your evidence is and you summarise it in your paragraph 119, that sheep and beef farmers have increased meat production while decreasing total animal numbers, and at the same time losing a lot of the productive land to other land uses. That would sort of suggest to me that the approach in IMP2 and the priorities in the National Policy Statement for Fresh Water are workable in terms of putting life supporting capacity in the area of the natural environment ahead of those other social and economic wellbeing type provisions. Do you have a comment around that?
First question related to, have I been following the hearing and the process? to some extent yesterday, but I'm not familiar with those specific provisions you're talking about. My focus in the evidence here was on the economics of farming, and as you point out, yes, even beef farmers have had been able to maintain or increase production from fewer animals and from less land.
Yeah, okay. I guess that kind of answers my question anyway, in effect, but thank you.
Then I've only really got one question that related just to your table right near the end of your evidence of paragraph 105, your table 2. And just out of interest, really, in terms of the revenue, the export value of deer, that 2135 million figure. What's the, do you know what the breakdown is between velvet and venison in percentage terms for that?
Not off the top of my head, no, I don't.
Could we get that information?
Oh, well, it's not. It was just to be aware of himself. It's more of personal interest than anything probably relevant to the process. No, they're just. I just wanted to observe that your evidence has given us a very clear picture. Thank you very much in overall economics terms for the industries that who have instructed you, and it's been very helpful and informative in that regard. I don't have any particular questions. Thank you.
Thank you, Mr. Chair. So that is us for this stage, and we will be back in April. Thank you.
And hopefully we'll be back in April equipped to address that challenge.
Absolutely.
Yes, I'd be very interested to see how you support through the High Court decision the proposition you advanced that we really have the control of the overall provisions of the policies making, including the freshwater aspect, and that's what I'm wanting to look at.
Yes, and the question of what including means, whether it's really the bringing of it all together,
yes,
in terms of section 59 for the purpose of the RPS as an instrument.
Right. So the challenge was that you've made the submission that that was going to be our role. And,
yes,
that fitted in with some of the observations as already made. I was really challenging you to draw our attention to the particular observations you made that supported your problem.
Yes, no, absolutely. So it was that convergence and so forth. Yes, indeed, I'll do that.
Thank you. Ms. Hunter, if you could come forward, and can I just indicate, Mr. Richardson, we're not stealing your witness, but she.
No, I understand.
Yeah.
She's giving evidence for the context of this. Yes, thank you.
Right, no, all good. I'll push the question. Thank you.
Thank you, Ms. Hunter. So you've been good enough to stay last night, and I'm sorry we held you so long, but you made the offer to have questions today on that evidence for contact, and so if I hand over to Bianca.
Yes, thank you very much, and thank you for getting us home earlier than you would have last night. I do have one question, and this is just a point of clarification. In your paragraph 8.5 of your evidence, where you were discussing IMO 4, So you're you're making a suggestion there that does, I suppose when I read it, put quite a focus on energy. Is that the, I mean, I'm assuming that's the intention given your client, but do you accept that perhaps it's sort of shifting the balance really of what that subsection is trying to achieve? Or do you think that's appropriate in this instance?
I think it's appropriate, given Mr. Hunt's evidence for contact energy, which shows that we need a significant amount of new generation and retain the existing. And I think the key change here is I haven't changed it to assist with achieving to enable and then to be achieved, including by, so that's more of an example. It's one of the options. One of the requirements, rather. There could be more.
Yeah, okay. Steve, I think I have one other question, but I think maybe we've got that resolved. Yeah, just again, this is probably just clarification, IMP 10. And this is paragraph 8.15, the top of page 15. I just wanted to clarify with you that your subsection 2 that you've put there, does that replace the existing subsection 2 in that policy, or are you proposing that as an additional subsection?
I think that would be a new additional clause. Yeah.
Right.
Okay.
Okay. No, that's good. I think that was all I had. Thank you.
Thank you. Just in relation to the concern around, you'll be faithfully sitting through all the discussions around IM P1, P2. We've had various opinions on how that gives effect to the Section 5 purpose to Act. But if it was to stay in the form it was, I guess, given context, real interest is probably more in freshwater side of things, and there's probably a pathway, I think, through that maybe, but that priority is in the freshwater management plan process. What is your concern here and how it's extended to the rest of the natural environment in terms of context of particular activities? Give me an example of how you think it may impact on what they do.
It is probably less of a concern in the freshwater context, because I do accept that is the prioritisation set out in the NPS. So the issue with that one for contact would be in the development of new assets within the region. So that would be on focus of wind and solar in particular. And the conflict with the ecological type provisions, the landscape provisions, the heritage provisions in this regard. So there would be conflicts in developing new large scale wind farms, for example. Even solar farms with regard to soils and all sorts of things. There'd be conflicts arising. So there'd be a potential that you'd have to come back to this.
So the EPS for renewable energy, you have to refresh my memory on evidence on that. Is there a pathway in that to resolve those conflicts?
There is to a certain extent. Unfortunately, the language within that NPS for renewable energy is not as strong, for example, comparatively to the NPS for freshwater. So that's unfortunate in terms of its drafting. So there may be some resolution by reverting to that higher order document, but it's not clear entirely that there is a pathway there.
And sort of related to that was, I think you highlighted the concern in P12, which we sort of highlighted yesterday with despite other provisions in Yeah, yes. In that subsection 4, this is your paragraph 820. It kind of neutered that policy in a way that still referred back to the objectives of that, and you're recommending that comes out. But you haven't changed any of the limits, reference to limits in there, and that is a concern for you in policy 14. Yeah, and I think you were hearing this, McTy was talking about the concern around people have limits being referred to and the activities. Her view was that, well, we really shouldn't be too concerned about that being in the RPS because they're going to be set in a regional plan or a district plan. And what's your view on that, given you work through all of those plans when you deal with these sorts of things?
Yes, and I think in terms of that 5, I haven't got the right most up-to-date wording in 8.20 of my evidence. I think that limit has been removed, that reference.
Oh, okay. Yeah.
Just clarifying that. And I do have concerns in terms of the approach to limit, particularly in a district plan type sense. You know, I accept that there are, and what we're familiar with in terms of the increase of freshwater and then what that correlates into regional planning for freshwater, there are limits there, you know, there's limit on allocation, they're quite understood in practice under the RMA. But I'm not quite so sure how that translates in the sort of district planning context, because there's, you know, limits, are they role standards, are they prohibitions? What is that context in particular?
Yeah, especially with some of the issues you'd be dealing with would be landscape, for example. Well, I've asked a number of questions here. There's a difference between a limit and a threshold, and threshold has actually disappeared, which that's actually useful for an RMA district planning at least.
Particularly in district planning, and I accept that, as I said, from a regional context, limits make more sense. We're more familiar with them, we understand how they play out in regional planning.
Okay, well, that's all I had really. Your evidence is very clear, and I think that the bulk of it will be dealt with in that later hearings. Thank you.
No, I think your evidence is very clear on the issues that were addressed yesterday. Just one possible issue that probably hasn't arisen, but it just listening to the exchanges you were just having. Should there be in planning terms any sort of recognition that opening the door for new generation to try and meet the climate change imperative that's come from the national direction might need to take account of effects of scale of those on significant landscapes. So basically what you're saying is we need a consent pathway because we're facing these SMAs or we're facing significant landscapes as well. And I'm just wondering, is the issue of scale something that from a planning point of view should be identified as having some effect?
Yes, I do think that scale needs to be thought about. My understanding the way the technology is moving, particularly in terms of wind turbines, is that you can, it seems bigger is better, so you can have less turbines, but they're larger, so they produce more. So there's, depends what you're talking about in terms of scale. So they might occupy less of an area and things. So scale is certainly a consideration.
I just have a very vivid memory of driving up from the coast in Canada and getting up onto the prairies and seeing nothing but nature until we hit the prairies, and suddenly there was just a sea of solar panels as far as you could see. And had it been at a lesser scale, I don't think we would have had that.
You wouldn't have
sudden
so
shock.
much, And I think we probably need to make a call on that, you know, if we're in terms of the direction we're heading in.
Is it something that should be reflected at regional policy statement level?
To the extent that it can be, I think, it's difficult. As I say, things change and the technology changes too. So, before I think there were larger scale wind farms in terms of land area, but now they might occupy a small area, but they're bigger. So whether or not that is worse or less landscape effects, it's hard to determine at this point.
Thank you very much. Thank you. Probably just got to move. I'll see.
Move, yeah. I'll move over.
Morning.
Yes, good morning. Hello again, panel. So I understand the topic that's exercising us today is the IM chapter, and that's what I've come to talk to you about. I wasn't able to listen to the conversation yesterday, but Ms. Hunter did let you know that the priority decision-making provisions in the proposed regional policy statement were the subject of some discussion and exercising your minds. So I hadn't planned to make any legal submissions today, but in view of that, I thought that I would offer my thoughts in the hope that they might assist you. So I prepared a brief submission, which I'll take you through if it's convenient.
Absolutely. And we asked for a decision yesterday that came to us and whose name was there as counsel for the primary parties. It was yourself. So let's see. One just I can't remember the name. The High Court decision a year or so ago. Happened on the issue of a board.
All right.
You're right.
I assume I was awake.
Help me out for a second.
Sorry, sir, the High Court decision from the original OGL appeal in 2018 that was appealed to the the Environment Court decision, which was appealed to the High Court, which just was sort of on those provisions and the appropriateness of limits or not. And
This is
word of
the
authority.
partially operative RPS
Yes, yeah.
appeals.
I think that there was a 2020 decision.
All right, well, if
You
there ain't,
remember being-
I do remember that.
I
Yes.
remember you there.
Yes, I do remember that. Well, I'm not here to talk to you about that.
No.
But it may be that does come up in the context of the eco provisions later on when we get to talk about limits and offsetting and compensation and so on. That might be relevant then. Anyway, for today,
Okay.
talking about the IM provisions. In these submissions, I comment briefly on the hierarchy of priorities for decision making as contained in policy IMP2, decision priorities, and that's as contained in the notified version of the proposed regional policy statement. Oceanic Gold made a formal submission opposing that policy, and in that it said this direction is derived from the National Policy Statement for Freshwater Management 2020. Applying this hierarchy is mandatory to all decision making within Otago effectively usurps the requirement to promote sustainable management, or inappropriately implies that promoting sustainable management and following this hierarchy are the same thing, and is likely to cause implementation difficulties, as in certain circumstances there will need to be a more nuanced approach taken to resource management within Otago. Oceanic Gold sought that the policy be deleted, or in the alternative, if the policy is retained, that extensive changes would be required elsewhere in the document to reflect the reality that the promotion of sustainable management would often require a more nuanced approach. In the section 42A version of the proposed regional policy statement, it's proposed to merge policies 1 and 2. The default decision-making priorities originally in policy 2 have been retained in an amended form that conflates the first two priorities, that is the life supporting capacity and Māori of the natural environment and the health needs of people. The intent is that when making decisions, these matters are always to be prioritised above the ability of people and communities to provide for their social, economic and cultural well-being now and in the future. Only where the proposed regional policy statement expressly provides otherwise is that prioritisation not to be observed. This approach sets the regional policy statement up in a way that will not promote the sustainable management purpose of the RMA unless it is accompanied by extensive exceptions in the other parts of the document that provide for all the possible instances where sustainable management might require the default prioritisation not to be observed. Mineral extraction contributes in a variety of ways, as you heard in the earlier part of the hearing, to the ability of people and communities to provide for their social, economic and cultural well-being. The activity by its nature depletes the natural mineral resources being extracted and has effects on other resources that cannot be avoided and must be carefully managed. In that context, and in the absence of appropriate provisions elsewhere in the document that protect access to valuable mineral resources, that recognise the functional needs of mining and that allow the use of the full effects management hierarchy rather than just avoidance. To address adverse effects to achieve overall positive outcomes, it is entirely unclear what prioritising the life supporting capacity and mauri of the natural environment above providing for the well-being of people and communities will mean in the context of mining. The decision priorities appear to be borrowed from the particular context of fresh water as set out in the National Policy Statement for Freshwater Management. The NPSFM is to be understood as an expression of what sustainable management requires in the freshwater context and must be given effect to in the proposed regional policy statement according to its terms. While the NPSFM recognises that all resources are interconnected to tai, it does not provide a basis for extending the use of the decision priorities to other contexts beyond freshwater. To do so effectively flips the concept of sustainable management on its head. In the RMA, sustainable management means managing the use, development and protection of natural and physical resources in a way or at a rate which enables people and communities to provide for their social, economic and cultural well-being and for their health and safety, while sustaining potential of natural and physical resources, excluding minerals, to meet the reasonably foreseeable needs of future generations, safeguarding life-supporting capacity of air, water, soil and ecosystems, and avoiding, remedying or mitigating any adverse effects of activities on the environment. The purpose of the RMA is to promote sustainable management as defined. The purpose is to manage natural and physical resources to enable well-being, health and safety. The three wild statements are to be understood as bottom lines or limits that must be observed as resources are managed to achieve well-being, health and safety. Without doubt, in a natural world that has real capacity limits, observing the wilds has real implications for the ways in which the enabling purpose of the RMA can be achieved. And that is reflected in the particular context of freshwater as expressed in the NPSFM. In my submission, though, the default decision priorities in the IM chapter of the proposed regional policy statement are not consistent with the sustainable management purpose of the RMA, because while using different language to express the wilds, they seek to promote those matters, or at least life supporting capacity and mauri of the natural environment above well-being. In the case of the health needs of people, the priority prioritises this above well-being, whereas the definition in the RMA contains no such priority. And I know that Masanta is to give very evidence on that topic. So this might be very brief thoughts. I don't know whether it's something you want to have a conversation with me about, but I know it's an important matter for you to consider. Thank you.
Yeah, and thank you for your submissions. This is something we did hear a bit about yesterday as well. And taking the point that you weren't here, we did have some submissions. And I was just looking at my notes. It was Pierce, wasn't it? Where it was put to us that I suppose, I mean, it's been developed for freshwater, a hierarchy has been developed for freshwater under the NPSFM. There would need to be a lot of additional analysis from a Section 32 perspective if it was to be applied wider than that. And the same is sort of said around limit setting as well. I mean, do you have I think your submissions are reasonably clear, but I also put to him that if the NPSFM hierarchies were consistent with Section 5 of the RMA, then the hierarchy approach must therefore be. Do you have any sort of response around that?
Well, as I say in my submissions, I think as a matter of law, it must be accepted that the NPSFM represents what we consider to be an expression of what sustainable management requires in the context that it applies to, which is freshwater. There is no such national direction in respect of other domains. And so that's deliberate. It's not relevant that there might be changes under new legislation that's currently before the House. Who knows what that might look like, but we are dealing with Resource Management Act as it is today, and we're dealing with national direction as it is today. And so absent, in my submission, absent some clear direction at a national level, which says the approach that's the approach that's been found appropriate for freshwater is to be applied generally. It oughtn't to be applied generally.
Yeah, okay, thanks.
Yeah, thank you. I guess what fell out of the conversation yesterday for me, and it was around the King Salmon case, and Chair puts it way more eloquently than I ever can, but it's around thinking about your void policy and the protectionism in section 5, and that link with the MPS freshwater is about a particular matter or issue that is being raised, and it doesn't necessarily mean it can be widened to everything. It's specific to an issue of concern, really. That's what you're saying.
Yes, I am, and I think that the concerns that we're trying to address through the MPSFM around the apparent inability of our previous policy settings to properly manage in a sustainable way our freshwater resources, so that we're seeing decline, prompted a particular response at a national level, and that's as it should be, and as the Act provides, and we all fall into line as we work down through the hierarchy of instruments, and I think that the difficulty with the approach and the proposed regional policy statement, first of all, I mean, it's particularly difficult for the extractors industry, because whereas the sustainable management definition expressly recognises that minerals can't be sustained by their nature when they're used, they're used. The RPS totally ignores that. It has nothing to say about that in the integrated management chapter or anywhere, and so that's egregious from my client's point of view. That aside, the importation of the Judge Borthwick's division of the Environment Court calls it a paradigm shift in the MPSFM, in the way that we think about our water and freshwater resources is simply not reflected in the way that we are required to address other domains. In the Act, there's no reason to read the Act or read section 5 as justifying or supporting the importation of the MPSFM's approach right across all domains.
Seems to me that one of the real challenges is aligning the MPSFM up against other things. I mean, sure, it relates specifically to fresh water, but I think in the Māori world, you would align the Ki Uta Ki Tai paradigm or philosophy very much to the greater, wider aspects of life, not just fresh water. Yeah, and I hear what you're saying here, that it's hard, the extractive industry, that the two things don't necessarily go that hand in hand, like hand in glove kind of stuff. And I kind of struggle sometimes to align the two things in a way that I guess breaks down the barriers, because there are barriers in the way in which Western science, for example, looks at the world.
Yes, I accept what you say, and I think it's becoming easier for us to marry these things in the context of even a simple Western science concept of the way we use land can affect our fresh water. We've kind of got the idea of that now, whereas perhaps in the past we didn't really get that as well as we needed to, and we're living the dream of land use changes that perhaps with the benefit of hindsight we mightn't have wanted to make. So that linkage is recognised in the NPSFM. It's in my submission, the NPSFM is about saying, be careful how we use and protect all of our resources in the sense that they're interrelated with our fresh water. And so don't fall into the trap of thinking that what I'm doing is just affecting my piece of land. I don't have to think about what that might mean in the estuary downstream. That's not appropriate, and the NPSFM deals to that. That's not what I'm talking about. I'm talking about a situation where outside of the freshwater context, we're importing the freshwater NPS's concepts, and we don't have a mandate to do that. And it may have some significant consequences for the way that wellbeing can be provided for in the region if we do that. And we haven't accounted for that. There isn't any analysis of that. And my client's saying from its perspective, it has real concerns because it appears that we've lost something in terms of a recognition of the particular nature of the mineral resources that we have in the region.
I understand what the problem is. I mean, you've made that quite clear. I guess my issue was around how you minimize the gap, I suppose, if there's such a thing. I'm not quite sure whether there is a gap, but there's a philosophical gap in many respects in what the SFM is saying, which is more the Kiuta Kitai philosophy, and the more I refer to blithely as the Western science approach, because that compartmentalizes things. You know, that bit belongs there, that bit belongs here. They all belong in different bits, and often the connection is not made, or the theology is to keep those bits separate. They don't connect them seamlessly. If that's the point. I understand what you're saying. I just wondered whether any thought had been given to ways in which you could minimize, if not contract, the whole issue, so that we're not saying on the one hand we've got this, and on the other hand, you know, the extractive industry is saying one thing, but I'm not arguing with what you're saying.
No,
I understand what.
I appreciate that, and in some ways, I think the working parts of the RPS are an attempt to grapple with that, because we do have objectives and priorities for different domains and in different contexts, which are our best attempt to try to reflect how resources are interrelated, and how, when we're doing one thing, we need to keep an eye on how it impacts on another thing. And so we don't always get that perfectly right. And I guess the challenge to us all is to continue to learn and to think broadly about the nature of those connections so that we don't miss them. And then rue the fact that we have neglected to recognise connections that are there.
Thank you very much. I have no other questions.
Just as I was listening to you, I was looking also at the Supreme Court's expression in the Margaret cases, where it said that the definition of sustainable management, that is, the definition indicates that environmental protection is a core element of sustainable management, so that the policy of preventing the adverse effects of development on particular areas is consistent with sustainable management. Now, against that background, if this priority had been worded in a way that enabled a recognition, and there's a use of the phrase that Mr. Hewitt's been discussing through the hearings already, of tipping points or potential tipping points for particular aspects of the environment, that it had been worded in a way that recognised that if those were looking like occurring, or we were getting close to them, that this was to be the priority applied. Would you have a problem with that type of approach?
That sounds better to me, in the sense that it, if you like, it focuses the circumstances in which this priority would apply, as opposed to, at the moment, it's expressed as this is the default priority, and only if the instrument expressly kind of reverses that priority or does something different, would you apply a different priority? Which as I say, to me, it does sort of, it tips the way the Act talks about sustainable management on its head a little. And I want to be clear in saying that in my submission, or in my expression of that, I'm certainly not saying that the policy statement should provide for those whiles to not be recognised. That's not the intent, and I don't think the regional policy statement can lawfully do that. I think that's a requirement of the Act, that the enabling of the use and protection of resources happens within that context and subject to those bottom lines. But to make the bottom lines more important than the enabling purpose of the Act, I think is an error.
Yeah, it just seems to me that a regional policy statement could properly identify situations where the evidence may yet arise over the period of the regional policy statement, where those sort of tipping points in relation to other aspects other than fresh water might become of concern.
Yes.
And, that the policy statement should be leaving the door open for mechanisms, whether it be by way of plan change or whatever, to address those tipping points as they start to become a particular concern.
Yes, and the way that I think about that is that if the evidence supports the conclusion that that at a certain point, it must be the case that going any further can't be allowed, because to do so will not safeguard or will not protect, as is required by sustainable management. That's where avoid becomes relevant to me, because it's saying that is the tipping point, that is the bottom line, or the point beyond which we must not go. And in my view anyway, the use of simple avoidance policies needs to be well considered, because you've got to be very confident that there aren't ever going to be any exceptions to that. And one of the difficulties that we encounter with enthusiastic use of avoidance policies is that they actually stifle innovation and creativity. So instead of encouraging people to say, look, there's a problem here, if you're going to want to pursue your activity, you need to find a good solution to that problem. Instead we say, just don't do it. And that when we go on to talking about things like biodiversity offsetting and compensation, that actually says to somebody like an Oceana Gold, we would rather that you don't mine and leave everything in the status quo in a state of decline than mine and leave the environment in a better position because you deal with the pests and predators. And that's the risk that we run with avoid policies, because they are too blunt.
Thank you very much, and thank you for the submissions you've given.
And I think the sun is a hand up.
Yeah, you heard from me yesterday, and a lot of these points are very similar, so I will just run through these quite quickly. Just to set out that the provisions which are of key concern to Oceana Gold in the integrated management chapter are P2 and P14, and Oceana also made a primary submission on P10 and a number of further submissions across the integrated management chapter. The concerns in terms of IMP2 have been set out by Mr. Christensen and are similar to the issues I talked about yesterday with regard to contact. And I thought maybe a good way to present the issues would be to run through sort of scenario how this might play out in terms of practice. So looking at 1.5, Ms. Paul expresses concern in her evidence that there is no available consenting pathway in the notified or subsequent versions of the regional policy statement. She's explained that the mining activity is locationally constrained, and at Macrae's mine it's also been identified that a large portion of the site, including land currently used for farming purposes, would likely trigger a significant natural area SNA status under the current application of the biodiversity significance criteria, referring to Appendix 2 there. There is no currently available consenting pathway for mine activities under the eco provisions of the regional policy statement, nor are there currently any provisions in the other chapters that recognise the activity's benefits in terms of economic and social well-being, unless the SNA is a wetland or other freshwater environment, referring to any higher order document at this current time as the policy directs, will also not provide any further ability to resolve this conflict. Any new or expanded mining activity which triggers the SNA criteria would therefore create a direct conflict with the current provisions of the proposed regional policy statement. Under this scenario, decision makers would have to be guided by the direction set out in P1, and it is clear that if there are conflicts that cannot be resolved by reverting to the higher order documents, they would have to prioritise the life supporting capacity and Māori of the environment over the ability of people and communities to provide for their social, economic and cultural well-being now and in the future. In the scenario I've set out above, I think a decision maker would find it very difficult to find a pathway through this policy, which is to be read alongside specific ecological provisions that set out how the protection of biodiversity values and arguably the life supporting capacity of the environment is to be achieved, and that is through the avoidance of any adverse effect. Furthermore, offsetting and compensation or enhancements associated with the mining activity, which may provide the safeguarding that is sought by this provision, are potentially not available to be factored into this decision-making process by virtue of the current policy drafting within the regional policy statement. These issues reiterate OceanaGold's concerns that there is currently no pathway available within the regional policy statement of mineral extraction and mining activities. Oceana potentially becomes less concerned with P1 if provisions are inserted into the policy statement that recognise the industry's importance to the region, enable access to the effects management hierarchy and retain a consenting pathway. This would, potentially there address the conflict that would otherwise arise and therefore avoid having to defer back to P1 in all instances for any further development of the site. Turning now to P14, OceanaGold's concerns are similar to contacts which I talked about yesterday. They sought the deletion of this policy due to the inherently uncertain nature of the drafting, the lack of clarity behind references to various limits and states of degradation. And I talked about this yesterday in terms of my concerns that it appears to be preempting the new legislative regime under the Natural and Built Environment Bill. And I acknowledge that we might know a little bit more about what this might look like and that limits are a feature of that. There are inherent difficulties in trying to fit parts of this new regime into the RFPs at this time. And, simply because the RPS document is being prepared under the current provisions of the RMA rather than this future framework. I have particular concerns with clause 3 within P14, and that's referring to the requirement to regularly assess and adjust limits over time. It's unclear how this is intended to be given effect to in preparation of regional and district plans prepared under the RMA, which will be set for a period of time. It is also unclear what this might mean for existing consent holders. It might be this is trying to enable review powers which are embedded within the new Act. Alternatively, clause 3 could be interpreted to mean that the plans can set potentially less stringent or interim limits, which I wouldn't necessarily be opposed to, but again, this is a matter that appears to be derived from the MBE, but it's not clear and it creates significant uncertainties at this time in my view. In 1.12, I note that limits are an embedded concept in parts of our current resource management framework, such as the management of fresh water. But the concern I have with this policy is that it potentially has more far-reaching implications across all spectrums, which I consider to be inappropriate. I note there again that the method in M16 does provide some further direction by requiring regional district plans to establish limits wherever practical to support healthy ecosystems and intrinsic values. However, that is not clear in the current drafting of the policy. My preference is to delete this policy in its entirety. However, I would have less concern if it was clear that the policy related to ecosystem health and intrinsic values, as implied by the method, and it may also be appropriate for this policy to acknowledge that limits are likely to arise from existing and further national direction developed under the RMA, such as the MPs for freshwater and the pending MPs for Indigenous biodiversity. It would also be beneficial for the policy to set out that there are locally derived limits. They should be based on a high level of understanding of the state of the environment and a clear need to set specific limits in a given circumstance due to the values that prevail, and the process of setting limits should account for the full suite of costs and benefits of doing so, including the actual and potential costs on economic development and opportunities. And as I said at 1.15, if this policy remains, it should also be coupled with an acknowledgement in some cases there will be benefits associated with exceeding limits, potentially in an interim period, for example, where we might need to build new infrastructure, things like that, and or providing appropriate pathways for certain activities where such features are almost certain to arise, such as we've seen with the MPs of freshwater and the NES regarding wetlands.
Produce something here, but I did. I did have one question in relation to your evidence. Just check if it's something that's still relevant here. You're saying it, if we just turn to paragraph 8.7 of your evidence, I think this is something that you've elaborated on in your summary here as well, in relation to IMP 14. You're saying that the approach to requiring activities to occur within limits isn't consistent with the RMA sustainable management purpose. And you're saying here in your summary too, I suppose you go on for that, and you're saying that limits relating to ecosystem health and intrinsic values would, as per the method, will be okay. I suppose I'm just sort of struggling a little bit here that there are probably going to be other areas where limits may be appropriate. I mean, we've already got limits set for air, and I suppose they'll be coming through freshwater, although arguably that's part of the ecosystem link. But I suppose I'm just sort of thinking through where this sort of leads us. I mean, is your preference that the policy then, I know you said you'd quite like that policy to go, but if it was linking through more to ecosystem health, those sorts of things, so if the method was taken, that part of the method was taken, that would,
Yeah, I think
in your view, be okay. And I refer to what the chair was referring to before about where he was talking about priority applying where tipping points are being approached. You know, I mean, is that something that
I think having more guidance and certainty into the policy would be beneficial. You know, and despite the fact that I have criticised referring to the NB bill, I have looked at that in terms of their approach with limits, and they're quite clear in terms of the environments that the resource issues that they relate to. You know, I think I'm more concerned about how this would play out in terms of a district planning context, as I was saying before. You know, is a limit the same as a building height threshold, for example, in a district planning context? I don't think that it is, but it's just not clear currently.
I suppose we've got the likes of Kaitai's Sandra McIntyre saying to us that in IMP 14.1 that, you know, she doesn't like that wherever practical there, she preferred that to be taken out to provide more certainty for that policy, and is quite supportive of limits being put in place. The flip side is we've got yourself saying, well, we don't think limits are appropriate, and we question whether they're consistent with sustainable management.
Probably not that I don't think that they're appropriate, it's just how they actually play out in practice. It's more concern. You know, I understand there are limits on the air and water and things, and they're quite familiar with that in terms of the resource management practice. It's more how this then come, as they translate into all areas of resource management planning.
Okay, I think this is something we're going to have to grapple with a bit.
Yeah, I don't think that's the issue. We're just uncertain how this plays out in reality.
Yeah, okay. So hence if there was more guidance around limits, and then also in your view, a pathway that provided for
Yeah, I think,
for mining that gave you some more comfort.
yes.
Okay, thanks.
Thank you. You just sort of following on from that, Santa, is the P2 currently written policy and in the limits and all those things and the tipping points, they all sort of throw in. They actually are all related to this issue. From your perspective, in your experience, what would you expect to see in a section 32 around justifying an approach like that? And there's reference to tipping points, but we don't really know what they are. Is that priority over life supporting capacity in those situations of conflict? We have King Salmon that we've referred to quite a bit, saying, well, this is fine in particular places or environments or issues. That protection is invoked. What would you expect to see in section 32? Because I sit here thinking, I've written a few district plans and oh my God, I wouldn't want to go through that process. Because
Yeah, it will be expensive, I think, yeah.
and there'd be so much involved in it. So
Yeah, I
unless you've got a clear issue how.
After listening to the session yesterday, I went back and had a look at the section 32 that was prepared for the MPS for freshwater.
I
That
thought
was
you were going to have a glass of wine.
It's- yeah, well, true. That was, that's about this big in terms of page length, and it does have quite a lot of analysis, and it also draws in a lot of background research that was done in terms of, I had a look at particularly how the priority came about, and it was set out in the Action for Healthy Waterways, which was a whole, research program that the government completed prior to making the 2020 changes to the MPS.
Yeah.
So it'd be a lot of work to make this fit for all, but and maybe I'm not saying that necessarily has to be done at RPS level, but I think that there needs to be an ability when you're writing limits in the regional district plan that they know where they are and what they have to look at when they are setting those limits and things, and what work they need to put into the section 32 analysis.
I guess the chair raised what I think is probably quite a valid sort of point. It's the life of the RPS, and you might get to a tipping point and something through that, and there's a framework there then.
Yeah, I think that there's a clearer framework. I've interpreted that looking at
so you may not need a full blown.
I don't think it necessarily is not on this point, but maybe there needs to be some parameters about how those limits set and what they need to be looking at.
Yeah, talking about limits, and your main concern I get from Oceanic Gold is probably around biodiversity, and the impacts that mines have on that, and that's probably one of the tipping points that are being referred to. But
yeah, well, for example,
deal
if
with
there
that?
was a limit that just said you can't do X area of habitat SNA, then that that would be really difficult if that was just the blanket limit to work through.
Yeah, and I think from what I hear from you folk is that, particularly in the biodiversity space, it's not necessarily just about losing something. It's actually, well, we have to lose that, but over here we're going to make it better. Some would probably argue that no, you've still actually lost the opportunity to actually make it all better. I still,
But then you've lost economic and social
yeah.
benefit too.
Yeah, but if we put it in the context of a limit and the tipping point, you're still kind of in trouble there. I was just thinking aloud, sorry. I'm trying to get my head around this.
I think that's the trouble for all of us,
Yeah,
with this.
yeah, but going back a step then, so you wouldn't be adverse to a method or a policy like that that's framed a little more definitively around when it will kick in if there is an identified tipping point in a particular environment or something, then maybe you use that, something like that.
Yes, I think that would provide more comfort.
Okay, thank you. One other question. A bit confused about what evidence I'm looking at in your section. There was something, your concern around method 1. And you've recommended there should be some changes around that, and again, it's sort of the same thing. You don't have any wording for that, or have I missed that? Is that in will that come through in the energy section or something?
What are you referring to?
Your paragraph 1.14 today, you were talking about uncertainty. I think would be reduced if it was clear that limits and
Oh, yeah,
and various
yes.
other things.
Yes, I mean, I think, yeah, so,
It'd be handy to see like a redraft provision around that, which is that to work.
yeah, because all that method says is establish limits wherever practical to support health ecosystem services and intrinsic values. So that doesn't provide any further guidance, policy does, in my view. So if there was more detail in the method, that potentially could provide more comfort as well.
Okay, thank you.
Listening to some of those exchanges and some of the submissions that Mr. Christensen made, when you read your 1.6, the third last line, I noted that you left out the word natural. Would have to prioritise the life supporting capacity and value of the natural environment, and natural is in the proposed issue 2, and issue 1, sorry, and I just wondered if we looked at that and changed the wording to prioritise the life supporting capacity and loading of the environment, and if you change it to the environment, either natural or enhanced, would that assist a consent pathway? Because in essence, what Mr. Christensen is saying is, in reality, at Macrae's, you have the options of either leaving the natural environment as it is, which is argued to be a bit degraded, and the other option is to look at an extractive use that enables the resource to be used, but having mechanisms whereby the environment in a broader sense is enhanced.
Yes, I am not opposed to that, and as I say, in 1.7, I actually think offsetting compensation and enhancements can also provide that safeguarding that's been sought by this particular outcome. But it's just that I don't currently, for Oceania Gold, there is no pathway, so there's also no ability to offer offsetting or compensation in an ecological sense. So from the reading of this policy statement, you couldn't apply those broader concepts to achieve that outcome.
Because the word natural is used with the environment.
Yes, that would be.
It doesn't allow for enhanced environment.
Yeah, and also in what the subsequent policies are in this particular document. I don't think offsetting and compensation or enhancement is available currently for Oceania Gold activities.
Yes. Right. My next question is dealt with Mr. Cubitt. Yeah, just in terms of, can you assist me? I mean, I haven't looked closely because that national policy for Indigenous biodiversity has just been around for so long and it's changed so much, and I've sort of lost touch with it, to be honest. But what sort of limits are in the current iteration? How are they described? How are they, in terms of measurement?
I think they, I don't know off the top of my head, this even might have a better answer here, but there are limits in terms of offsetting and compensation as to when you can and can't do those. I'm pretty sure in the current version.
Sorry.
There are limits as to when offsetting and compensation is available in certain circumstances.
But it is recognised offsetting and compensation as
Yeah.
within that
Yeah.
draft.
But then there are limits, and so, you know, if it's particularly your high value threatened type species that can just snow replacement, you couldn't offset or compensate for that.
Right. Well, thank you for your evidence. Thank you.
Yes, thank you very much, sir.
Now, we got off the timetable a bit, and the reason for that was that we had a very late night last night, and Hunter was good enough to accommodate us, and we felt that we accommodate her, but then doing that with me, that's the kitchen, and you got to jump the gun. So when we go back to the timetable, the Director General of Conservation.
Okay. I perhaps we'll start with an apology. I had intended to come along and simply say I'm happy to take any questions. I found the discussions yesterday and today very interesting. And with your leave, I would like to just step through my evidence and update and respond to those discussions that have happened where I may be able to hopefully assist.
Absolutely.
Hopefully, it means we won't have those questions.
A little become clear. So I guess the first question in terms of IMP1, P2 and prioritisation, in terms of my evidence at the page 14, probably starting there. From the discussions, the first thing I'm turning my mind to is whether the prioritisation that is proposed in the RPS is available. And there have been some discussions that while it's in the MPS FM, that applies to freshwater, and essentially without that national direction, it's not available to be used elsewhere. And it's my clear understanding that the lack of national direction is not a bar to the ability to use it. The fact that the MPS FM has adopted that prioritisation approach makes it very clear that is an available option, that is a way that is acceptable in terms of planning. Which the next question, which is yes, it's available, but is it justified? There is considerable evidence there is considerable information in Section 32 report, and particularly reports provided by wildlands consultants around the state of natural environment and biodiversity in Otago, and also evidence from certainly the Director General's witnesses, technical experts, which in my reading is quite clear that there are real issues with the state of the natural environment and biodiversity in Otago. So I'm comfortable that there is an evidential basis there for the panel to adopt that approach, which I consider is available. I do accept the concerns that OceanaGold have, but I don't see that prioritisation as necessarily a barrier. My evidence, and that again of some of the Director General's technical experts around offsetting and compensation, would significantly change how they operate from what was in the notified version of the RPS. And I consider that would give an available pathway to the likes of OceanaGold. I was very involved with the Deepdale North 3 development, where they did adopt quite an extensive program of offsetting and compensation. And if that project was going through the proposed prioritisation, I would be quite comfortable that it would need to firstly secure the long-term life supporting capacity and Māori of the natural environment. So I think that there is a pathway available. But with that, noting that that has to be proved on its merits. So in that particular case, with Deep North 3, sort of essentially all the experts agreed that what was proposed in offsetting was better than what was being lost. That's not always going to be the case. If that's not the case, if there are tipping points that are being breached, then they wouldn't be able to get consent. If that would be on the merits. And I understand the concern is about simply not having a pathway available. So it's my opinion that that prioritisation can be retained within the RPS without inappropriately blocking off pathways to development. The issue then is to make sure that the sort of the more machinery aspects of the RPS aren't what causes the problem, but that prioritisation I think remains both available and appropriate. So that's the starting point. But if the offsetting and compensation provisions were changed, then as was worded and notified, version decision priorities IMP2, unless expressly stated otherwise, so you go to the provisions for offsetting and compensation and how they're expressly stated. If that creates a pathway where Oceana Gold or other developers can meet those requirements, then in my opinion, they'll be able to meet that prioritisation approach. My next turn my mind to, so if prioritisation is retained within the RPS, how's it expressed? The notified version had a 1, 2, 3, firstly secure the life supporting long-term life supporting capacity of Māori, the natural environment. Secondly, promote the health needs of people, and thirdly, safeguard the ability of people and communities to provide for their social, economic, and well-being now in the future. The 42A report has rejigged IMP1 and IMP2 and brought the health needs of people, and with that first priority of the life supporting capacity in Māori, I have concern with that approach. I think it inappropriately conflates those two things. As I've referred to, the evidence is quite clear about the issues with the natural environment in Otago. So I think there is a justification for having it as the first priority. I was also very interested in Dr. Somerville's discussion around food production as being part of meeting the health needs of people. And I am certainly open to that idea. It's pretty clear that if we don't have food, we die. So there's a pretty direct correlation there. There is a less direct correlation as to whether we need to meet our food needs through beef and lamb. There are issues, both for and against how healthy beef and lamb and red meat is for people. The farming operation is clearly partly about providing food. It's also about economic activity, export, supporting communities. And I have real difficulty with bracketing that with life supporting capacity. I think if it was to be a two-step prioritisation, bracketing that health needs, particularly if it's broadly interpreted, bracketing that with the ability of people and communities, like their social, economic and cultural well-being, that is much more workable, because how those health needs of food production, for example, operate is going to inevitably interact with those social, economic and cultural considerations. So if you're going to bracket them, I think that's the appropriate place to bracket them. And it then becomes something that it wouldn't be my preferred drafting, but I think it would be workable. I don't think bracketing those wider considerations with the natural environment would be workable. I just check through my scribbled notes because there's been a lot happening. So the other matter I raised in my evidence, paragraph 57, was relating to managing cumulative effects. And again, this is something that is long from being a standalone policy from the notified version to the 42A, maybe a supplementary evidence stage, recommend that be combined. My preference remains, as per my evidence, for it to be a separate policy. I think while cumulative effects are part of the definition of effect, the reality is that they don't tend to get a lot of attention, and a lot of the reasons, for example, behind the promulgation of the NPSFM has been about the failure to adequately address cumulative effects over time. So I think it warrants its own express policy. There was some discussion yesterday about rewording the 42A combined version in a way that makes it clear about the status of cumulative effects on, and there was some wording also discussed with Ms. McIntyre. I am open to that, but would still prefer that it's set as a separate policy, and that it's very simple, it's very clear for the reader in terms of the importance of managing cumulative effects. So that's, with your leave, sort of my updates. I do recognise that it's a discussion. We're probably going to continue, but with that, I'll take any questions.
Thank you, Mr. Ross. No, and very helpful what you've done.
Just having a look here, you've actually covered off the main questions I had through your summary. Oops, turn that off. You had covered off the questions I had through your summary. It was very helpful. I'm just digesting that to see if anything else is popping out the end of it. I think no, I think that's fine. You haven't highlighted anything just in your summary here about P12, which is around limits and climate change mitigation. I mean, do you have anything you want to highlight to us around that? Because I think it does sort of seem to link in quite closely to the discussion that we've had just before around tipping points and prioritisation and various other things.
Yes, I didn't address that in my evidence, I guess because I am comfortable with the broad principle that, you know, given the impact of climate change and the fact that it's a very long-term impact, that there may be, on a case-by-case basis, on merits, cases where it is appropriate to provide leeway that you wouldn't otherwise provide. From the discussion that I've followed, I do see that there's potentially an issue with the drafting, and I think that probably needs to be revisited. I don't have an alternative to hand up, but I guess my overall feeling is that if the drafting is correct, that approach is appropriate in some cases to provide a pathway for those activities. And I think, again, doing so, if we look at the life supporting capacity of the natural environment, the 2 words before that are long term, it's really hard to avoid the long-term impacts of climate change as a very serious issue. So potentially providing that pathway through that policy does fit that, particularly that long-term focus.
Yeah, okay. No, thank you.
Thank you. Good morning, Mr. Brass. I think, yeah, in your a very useful summary of how the latest oceanic gold application works, you kind of hit the nail on the head in that. I think in terms of their issue, it's the priority thing you mentioned it well, provided machinery parts of the RPS are working properly, then it shouldn't be an issue. I think they're saying that they're not. So that's a concern when you throw in the work policies. I guess the biodiversity thing, yeah, I can accept that's where you could see a tipping point. Like, I've been in this game 35 years in Otago, and I don't know if there's been a significant change from when I started to there now, because it has been in the forefront. But maybe there's some evidence that suggests otherwise, but I don't know if there's been significant change in that, but probably more of an issue around, and I know you're a doc witness, but highly productive land is probably where I see a bit of a concern there with that sort of approach. When, I keep banging on about it, the Cleveland district scenario, which you'll know well, it's like pretty much all highly productive land. So you have an issue, you got conflicts everywhere there. The higher order document, the RPS, and their ability to give effect to enabling development. But I was wondering what your view sort of aligns to what the chair was talking about, a policy where you have a mechanism that if there is clear evidence that there is a tipping point arising during the life of the RPS, that then this is an appropriate way to deal with it. Is that kind of how you see it working? That you don't probably need a massive section 32 to justify vital ore resources, but there's a process in place when we've got a problem and we can fall back on that.
Yes, that is how I see it operating, and I won't speak to highly productive land because that's not an area that I've looked at deeply.
Because that's what we're grappling with, because it's not just biodiversity, this applies to everything. So.
But yes, in terms of the area that I'm familiar with, in terms of biodiversity, for example, the Deep Down North 3 issues were particularly around some loss of some ephemeral wetlands, habitat for lizards. In that case, the offset and compensation package addressed that. In the alternative drafting that I'm supporting for offset and compensation, there are still limits to that. So if, for example, an activity, a development was going to affect a threatened species of galaxid, and there are quite a few of those in Otago with very small fragmented populations, so they're at quite a risk. So I don't have any difficulty seeing a situation where you would say, that would be a tipping point to potentially drive a species to extinction, or significantly increase the risk of extinction. Those limits to offsetting and compensation, my understanding is that they would capture that situation so that they would work to capture those tipping points, if you like.
Yeah, okay, so that's interesting. So that's where you'd see the limits coming, and that would be set in a regional plan context or district plan context around if you're freshwater, you're in regional plan, terrestrial district plan.
Yep, and that would work equally whether it was a galaxid or a lizard, so freshwater or terrestrial. I've spent quite some time looking at the drafting and what's proposed in the Director General submission around those limits to offsetting and compensation. And my view is that they would work to provide for that while not acting as a an inordinate or unnecessary barrier. So as I say, I think there would be a pathway available for the likes of OGL, but it would be on its merits and what are the impacts it's going to have, and can they be offset in complex living?
To confess, I haven't got that far in the reading, so. And the only other thing was the cumulative effects issue, which when I asked Sandra yesterday, why you singling that one part of the effects definition out, because and you mentioned, well, it gets overlooked, but it's a bit of crystal ball gazing, really, isn't it? Cumulative effects, that's the difficulty with it. It's probably not so much in terms of water and air where you have allocation limits, but in other things, it's a bit of a crystal ball gazing process, isn't it?
It is, and it's not easy. But as I say, and I think the MPCFM is an example, it's not something we've done well, which is why we're now needing some much stronger policy being driven. You know, plainly, the fact that cumulative effects as part of effects generally hasn't successfully protected the freshwater environment. So that's my reason for thinking that it does need express recognition. And I'm not saying that that makes it necessarily easy to deal with.
Okay, thank you.
I just had a conversation with the Oceania and Gold people beforehand. I don't know if you were here for that. And I was making the point around what IMP2 in your submission, paragraph 56, where you make the point that what comes first is long-term life supporting and Maori of the natural environment, etc., etc. And when I was having a conversation with Mr. Christensen, I was trying to see if there was a, I mean, you understand his point of view, I assume, because I did, but it is there is a tension there that hang on. That I think even for Maori, they kind of struggle with, you know, it just, and I'm seeing where you support IMP2, but that's a dock-wide understanding, is it, or is it just your personal one?
It's consistent with the Director General's submission, but in terms of that evidence, that's my personal view. But from what I know, it would be consistent with DOC's approach elsewhere.
It seems to me that under the IM chapter, that's quite a key component. Would you agree?
Absolutely. I'd have to say I cannot understand how that's a discretionary chapter under the planning standards. It's, I mean, to me, that's one of the key things that an RPS does.
Yeah. Okay, thanks very much. I don't know.
I just struggle with the use of the term natural environment, and just wonder if you think back to 1991 when the Act was passed, the whole concept of enhanced environments or compensation, offsetting compensation, just didn't exist. Something that's arisen over the last 30 odd years, and yet it hasn't been reflected from a statutory sense in the definition of an environment. And so you get policies like this using that terminology of natural environment. And you would have heard me put it to Ms. Hunter that if, and listening to you describing that Deepdale 3 experience, it struck me that in reality, what you were saying was that so long as you could, the experts could be satisfied that a threatened species was being enhanced in some manner, that an Oceania type proposal for Deepdale 3 was acceptable. So it seemed to me that that would fit with what I put to Ms. Hunter, that you could deal with that in that priority sense by talking about securing life supporting capacity and mode of the environment, whether natural or enhanced. And how would you feel about that?
I have some concern from a interpretation point of view that in the definition of environment generally includes those human elements. So you're potentially winding up with a situation where those things that are, in my version, picked up in the second and third clauses would also, through that broader definition of environment, become part of the first clause.
You can overcome that, though, couldn't you, by virtue of the fact that the definition of environment is the second part of it is all natural and physical resources, rather than the broader sense of environment, which, as you say, in the first part of the statutory definition includes people and communities. So that if this wording was to refer to resources, whether natural or enhanced, would that meet your concerns?
Potentially, but I probably would want to just think through the implications. Just one that is coming to mind is around highly productive land, which is not about, if you like, meeting natural environment needs, but meeting human needs. So that's what the highly productive land is to produce. Would broadening that definition of environment potentially bring HPL up to the top of the list, and the issue that Commissioner Cubitt has raised, does that then become a factor that trumps other things?
If you're talking about the enhancement of the actual natural resource, that limits it, doesn't it?
I think it does. So just to be clear, you're suggesting replacing natural environment.
Well, the problem you've got is that to overcome the problem of people and communities being in the definition of environment,
yeah,
you've inserted. Well, I'm not saying you.
Well, no, that's
policy,
yeah.
But you've adopted the same language, and so the word natural has slipped in to try and differentiate from, as I understand what you're saying, to differentiate from people and communities and what they're doing. And what I'm saying, drawing attention to, is that within the Act, the definition of environment has 4 aspects to it. One of them happens to use the word natural, but it uses it in relation to the word resources. And so what I'm suggesting is that by some combination that you prioritize the life supporting capacity and mode of the natural resource, whether enhanced or not.
I think if it was drafted with that reference to resources as opposed to that very broad definition of environment, that would potentially work.
The next point that I just wanted to ask you about was that movement of the second clause, the health needs of people. I suppose, in a way, what I've just been talking to you about renders that obvious. What I was going to suggest to you was that the definition of environment, including people, did it really matter? that you were moving it up there, but the discussion we've just had really deals with that already. So no, that's right. I don't need to ask about that. I think that's all, and but I thank you for the thought that you put in and given us to us this morning, and it's timely, and it's timely that you were sitting there and listening to the other. It didn't make me feel so bad that we made you do that.
This is why we enjoy being planners. Yeah, really interesting debates and discussions.
Thank you, Mr. Bright.
Thank you.
We're going to take a break for a quarter of an hour for the morning. Thank you. sound, the next people.
And DCC on.
Oh, DCC, sorry, are they? They are too. I've jumped ahead of myself. So, Mr. Rents.
Maybe he's left. Do we have a summary? Oh, we do have a summary.
We actually need you to speak, Mr. French, for you.
Kia ora, and good morning. I trust you can hear me.
We can indeed, thank you, and we can confirm for you, we've just received your statement that you prepared, thank you.
So I take it that you haven't had an opportunity to read through it. So if it's okay with you, I can do that.
Yep.
The first part of that up to section 3 you've heard before. I confirm that I have read the Code of Conduct for Expert Witnesses for this year, 2023. So to move on to section 3, where I summarise the scope of statement, it's very brief. Not sure whether you are taking these two separately, but because it is brief, I'd like to present them together: significant resource management issues and integrated management, if that's okay.
It's fine, thank you.
Thank you. Starting with significant resource management issues, I addressed 2 matters in my primary brief of evidence. The first is around the social impact snapshot for issue 4, which states that a social issue related to the transport network, in my opinion, it's unduly limited in its scope by specifying, amongst other things, road fatalities on rural highways. I do not deny that this is a significant issue, but it is also an issue that there are deaths and serious injuries across the whole of the transport network. And in my primary evidence, I provided a suggested amendment to address this. My second concern is with SRMR I-10, in that it is difficult to reconcile the general nature of the issue with the specificity of the issue statement. I suggested alternative wording for the issue and issue statement in my primary evidence that may be applied more broadly across the region. In my primary evidence, that's at paragraph 8.8. Moving on to integrated management, I list the things that I address there and move on to objective 1, which I agree with. My suggestion there is that because of the broad definition of environment in the Resource Management Act, the inclusion of ecosystem services is unnecessary, and I suggest deleting this phrase. Objective 4, I agree that that it is essential that there is an objective that climate change mitigation actions are implemented. However, within the national and regional level outcomes sought, there is a range of opportunity and aspiration that may be more ambitious, and I believe these should be recognised in the objective. I've provided some additional wording in my primary evidence, and I think that's at paragraph 9.5. For policy 1, I suggested some changes to IM policy 1 that recognises that an integrated approach to decision making includes more than the health needs of people. Safety and basic needs such as shelter and safe drinking water are also essential, and the risk of natural hazards is a matter identified in section 6 and should therefore also be considered in decision making objectives and policies. That's at paragraph 9.7 of my primary evidence. Policy 4, I agree with the section 42A report. And policy 6, the section 42A report has recommended some changes to IMP 6 that, in my opinion, provide clarification around decision making in the absence of a comprehensive data set. But I don't think that they address the question of what is unreasonable and how it can be determined. In my primary evidence, I proposed the addition of a clause that would help guide users of the regional policy statement, which I repeat there. Just to read it out, avoid unreasonable delays and manage uncertainties in decision-making processes by 1, balancing the advantages of more rapid decisions, which may rely on incomplete information, with any benefits that may be derived from having a more complete information set. So that's a balancing opportunity for decision makers there. Policy 8, I agree with the section 42A report recommendation. And policy 9, I noted in my primary evidence that DCC's submission in support of policy 9 was not acknowledged, and I would just like to make sure that it's not overlooked, because this policy is the only integrated management policy that calls for the reduction of greenhouse gases, which will be necessary to achieve net zero carbon emissions, whatever target may be included. Dunedin City has an ambitious target of 2030. Policy 10, I suggest some changes in support of policy 9, and the inclusion of reduced greenhouse gas emissions as an additional clause in policy 10. And I think this is a necessary part of climate change adaptation and climate change mitigation. The clause I suggest is reduce the emission of greenhouse gases to a level that enables Otago's communities to achieve net zero carbon emissions in line with prevailing government policy and international agreements. There's I guess, a corollary between policy 10 in the integrated management section and the natural hazard section, policy 4. And I noted that policy 10, IM policy 10, does not include relocation as a mitigation measure, although relocation is included in natural hazard policy 4 for some land use activities such as lifeline utilities and essential and emergency services. In my opinion, this is too narrow, and there should be support for the relocation of all lawfully established activities should that be necessary through this policy, that is the natural hazards policy, to enable the lower order documents to provide the appropriate framework for relocation to happen if it is necessary. And that's my brief statement for this morning. I welcome your questions.
Thank you, Mr. Prince. Yeah.
Yeah, thank you. Just one question from me in relation to IMP6. And I'm not sure if you've heard evidence from Sandra McIntyre, but she was quite concerned that through bringing IMP15 into IMP6, it was I suppose placing more emphasis on the unreasonable delay and less emphasis on the precautionary approach in managing uncertainties. Did you hear?
No, unfortunately, I didn't hear that evidence.
Yeah, and I know you haven't provided evidence on policy 15, but I suppose I'm looking at the amendment that you're suggesting there too, which I mean, I suppose, do you have any thoughts on possibly how we could sort of strengthen that policy if policy 15 was to be merged in with policy 6 to make sure that that the precautionary approach comes through a little bit stronger and that people don't just rely on that policy for I suppose the section 21 issues.
I think it's interesting. I think policy 6 is an interesting policy in itself because it provides guidance, but it does leave that decision up to the decision makers. And what I've suggested there, and I've deliberately put that in as clause 1, that there is a balance that needs to be determined in that decision-making process between making a rapid decision and not having all the information that you may need for that, and what would may be seen as a more precautionary approach by obtaining more information and the delays that result from that. And it's at a lower order level and where you have the rules and consents required around those. It is on a case-by-case basis, I think, that you reach these determinations. It will vary from quite minor applications where something is missing and significant applications where you want to move forward with the application. That probably doesn't answer your concerns or question, but it's a policy that does leave a lot to the decision maker, and I hope my suggestion balances that.
Okay, thank you. I mean, I suppose in relation to the precautionary approach, in my experience, it's often it often comes up where the information is actually just not available, and it doesn't matter how much time people have got, it's just not information's not there. But yeah, no, thank you for that.
I would have to add to that I've got a number of applications being considered at the moment that are now into their 4th or even 5th year. So sometimes you just have to move on.
Thank you.
Thank you for that. I guess following on from your discussion there with Bianca, as I read those provisions, and I think someone mentioned it yesterday. They kind of lead me to an adaptive management. It might have been actually the chair that raised that point. And it's not really referred to in there, and I don't know if there's a submission on it, but that's where my mind led me to that sort of tool that's been used in RMA management. And is that something that you think should sort of be worked into those provisions?
Probably, I agree with you that where you don't have enough information, then an adaptive management approach will mitigate and accommodate the changes that might occur in the future as you get more information. And that's sort of, I completely agree with that approach. So whether it should be included in this policy at the RPS level, or whether in response to the policy and the clause that I've included there could be something in the lower order documents. I'd leave that for your thoughts and consideration, really.
Yeah, I guess that was sort of the next question following out of that. Where should it sit? Is it appropriate? Is it a direction at an RPS level, or is it a tool used in those other plans? But there's something I think.
Yeah, personally, I think it should be in the lower order documents. This clause, this policy, gives the decision maker the ability to balance, I guess, outcomes on the basis of information available. But I think that the detail of that probably sits more appropriately in the lower order documents.
Okay, thank you. The only other thing is, and you probably haven't had time to sit through the last couple of days listening to the priority approach in policy 2. And you talk about it in the context of the new policy 1, which is combined policy 1 and policy 2 in the integrated management section.
Yes.
And you've made some suggestions there to add in safety and basic needs people, but we've had Kaitahu and a few others indicate that we don't need to do that, because if you're taking care of the Maori, the life supporting capacity, everything follows from that. So your health and safety, and that's kind of addressed. And it's probably elevating that a little too high in the order. because I think Mr. Brass mentioned it today, we all need to eat food. And so that brings in another element that food production land could be caught up in that. So I was just wondering what your view was on that. And we have the other view that's saying, well, we shouldn't even have this because it's stepping outside what sustainable management is about. Unless there's a particular issue identified, you can go down that more protectionist sort of route. But what's your position on that?
Yeah, I think you also need to be aware that this sits, the RPS does sit within a framework that has national environmental standards above it. So the food production, the high productive land issue is considered within the NES for that. And it's, I guess, a matter of framing the RPS policies and objectives in a way that supports the NES and provides guidance for the documents that go below it. In terms of prioritizing outcomes, it's really on a it's quite difficult, the RPS, but I think it does follow that there is an assessment at a case-by-case basis that identifies what the effects of an activity might be and how those effects might be avoided, remedied, or mitigated. I think the changes I've suggested there probably hit on the basic needs of people, that they are, that this is what is necessary, possibly even as a priority, to be considered, and that the things that sit below that are things that contribute to these basic needs anyway. So again, I'm not sure if that answers the question, but it's certainly a really interesting discussion.
Well, actually, what you promoted is quite interesting in the context of the highly productive soil NPS, because when I've been grappling with this, this is the one that causes issues for me in terms of how this might work.
Yeah.
Because there are conflicts with that aren't resolved through the planning documents and that because of how that works in certain districts.
Yeah.
But your promoted there probably is actually a pathway out of that. So yeah, just food for thought, I guess. So no, that was interesting. Thank you.
Thank you.
I've only got the one question to you, Mr. French, really, and it relates to INP 6. Just the suggested wording that you advanced, as I read that, to make it really sensible or readable to someone, you would to identify a benefit being derived from a more complete information set. You really just have to, don't you, add the words available from adaptive management mechanisms?
Yes, yeah, no, that would be an excellent addition. And yeah, I suppose it does go without saying that it is it's time bound as well. But if you have that addition, then you're considering the potential for more data to be available over the course of the consent period. So yeah, no, I'd agree with that.
And I mean that it's inherent that you're going to have that time, because usually adaptive management mechanisms involve a staging process over time.
Yes.
Once you've satisfied the environmental tests that might have been put in place for the first stage, or next stage, whatever it might be.
Yeah, and obviously as you get further down into the detail of consents, you have review processes that relate to those as well, and conditions that implement those changes. So, but having it at the RPS level as a policy allows territorial and regional authorities to implement those in their lower order documents.
There is one other issue. At 5.12, you referred to the need for the, you thought there should be a provision of the policy statement for relocation of all lawfully established activities should that be necessary through climate change.
Yes.
And I was just wondering, does the Dunedin District Plan have any provision, such provision for relocation at the present time?
Mr. Freeland might be better placed to answer that than I am at the moment.
Thank you very much, Mr. Bennett. Thank you.
Thank you. It's been a pleasure. Thank you.
Ravensdown. Welcome, Ms. Hooks. It's not often that I can say to someone that I'm not hearing before me that I've known you the whole your life. And it's nice to finally see you in a professional. Yes.
Thank you, Mr. Chair. My intention this morning is simply to present some contextual, the context for Ravensdown's interest in these proceedings, and my colleague, Ms. Taylor, will delve into some of the more specific aspects of those interests, and she will also appear in the subsequent relevant hearing sessions where I'm proposing for this area to only appear today. I'd like to just take you briefly through the summary of my evidence at the front of my evidence to provide that context for Ravensdown. Ravensdown is a farmer-owned cooperative with almost 2,000 shareholders based in Otago. Ravensdown is a science-focused organisation delivering quality agri-products, technologies and services, and is an integral part of the food creation process, whether the food is grown for livestock or for humans. We have primarily focused on our business area of interest in our assessment of the proposed Otago Regional Policy Statement. So those are the implications for our farming shareholders and also our own operations at our manufacturing site just out at Ravensbourne in our 3 bulk stores located in Oamaru, Milton and Balclutha. Dunedin Works was established at Ravensbourne in 1929 and manufactures around 110,000 tonnes of superphosphate and dispatches 160,000 tonnes of bulk product annually. It's a key contributor to both the local and national economy, and also plays an essential part in providing the key nutrients required for the ongoing development of New Zealand agriculture. Given the significance of the Dunedin Works and the upcoming 2025 expiry of a number of regional resource consents held for discharges from the Dunedin Works, Ravensdown anticipates that the Regional Policy Statement will be a key planning instrument for the reconsenting process. And I note that we've already begun work on preparing for that reconsenting process. We're looking to support we do support a robust regional policy statement that establishes a planning framework that aims to achieve long-term sustainability by integrating the protection, restoration, enhancement and use of the region's natural and physical resources. Given Ravensdown's areas of focus, Ravensdown through its submission sought to ensure that farming activities and associated rural activities are appropriately recognised and provided for, and that they are protected from potential reverse sensitivity effects. In relation to Ravensdown's industrial activities at the Dunedin Works and its stores, the focus has been to strive for the appropriate recognition and provision for industrial activities as resource users, as well as ensuring that the regional policy statement provisions set an appropriate policy direction for industrial wastewater discharges, stormwater management, discharges to air, and the ongoing use of the wharf at Ravensbourne. While some of Ravensdown's submissions have been adequately addressed through the recommendations of the Section 42A reports, recommendations and subsequent supplementary evidence, a number of matters, in my opinion, require further consideration and amendment, and Ms. Taylor will traverse these matters in her planning evidence. I'm happy to take any questions you might have either ahead of or in conjunction with Ms. Taylor's evidence.
It might be easier if we went on to Ms. Taylor and then dealt with the 2 of you.
Morning. I am just going to give a high level overview of the matters I was proposing for this today, which is in response to the definitions and abbreviations, integrated management section and the EAR provisions. So the matters we've covered in the first few weeks of this hearing. My evidence mainly traverses outstanding matters. So we're generally happy with the section 42A reports or supplementary evidence unless we say otherwise. There are a couple of sections where I just outline the reasons why we support the section 42A report. And the first one in that is as noted at FA in my evidence relates to integrated management and the proposed staff recommendations in regards to IM 03 and P10. The other matters relate to definitions. My evidence talks about the receiving environment definition and my request to delete that definition. I think it's unnecessary and not needed, and also confusing in the context of the broader coverage of the RPS in terms of the resources it relates to. And I have in section 5 of my evidence, I traverse the EAR provisions, requesting a number of amendments to a number of provisions to ensure the terminology is consistent with approaches used throughout New Zealand, and to also ensure that the provisions are logical and workable. So I wasn't proposing to go into that into more detail because you've read the evidence. Let's take questions.
Thank you.
Yeah, just the questions from me. You've probably, if you've been keeping an eye on proceedings and probably through, I suspect, some of the pre-hearing meetings, I might be aware that there are some industries who are wanting more recognition as significant industries, significant regional industries. Is that something that Ravensdown would be interested in? And I see that, you know, you are wanting additional recognition in the IM chapter. If we were a mind to head down that path, do you think it qualify?
Our approach is typically to work in with other industries and have sort of group representation rather than necessarily seek for something that is only specific to our own operations.
I suppose in terms of submitting on the RPS, we were comfortable of the provisions in terms of the industrial activities and the recognition that was provided in that. I am aware of Fonterra's approach and the suggestion for regionally significant industry. Anna and I have talked about that, and if the Dunedin Works met the criteria, whatever that shall be, then we'll probably be comfortable with that. But we haven't got involved in that discussion per se.
Thanks for that. And I just had one question. I think it's probably directed at you in relation to your evidence. Am I correct in assuming from your evidence that there's no quarries, that Ravensdown doesn't have any quarries within Otago?
That's correct. We have no quarries in Otago.
And to what extent a reverse sensitivity affects a real issue for you, and what sort of activities are the concern there? That's something else we've heard a lot from industries, and I suspect with air discharges it's a bit of an issue, is it?
I can probably answer that from two angles, one being the company's own operations and the other from our farming shareholders' perspective. So if I deal with the farmers first, and that's the urban expansion into traditionally rural areas and those typical reverse sensitivity impacts that arise from perhaps traditional urban dwellers moving into the rural environment and not enjoying some of the use odour as an example associated with rural activities, machinery. Perhaps it would be an issue also in Otago. Bird scare is associated with vineyards, spraying, all those sorts of aerial application of fertiliser in certain areas, those sorts of things that can arise as a result of urban creep into rural environments. In terms of our own operations, typically, you know, well, our site at Ravensbourne has been there since 1929, but there's still people moving in, people moving out of the area who are not familiar with the workings of an industry such as ours, which has noise, has, you know, dust. It's not extending beyond our boundary, but some of those, the impacts of our activities where once upon a time there wouldn't have been houses near to our sites. So it's always a conscious. We had an example recently at our Dunedin Works where we've been undergoing an asbestos replacement program and taking asbestos cladding off our buildings. However, we've discovered in doing that the new cladding doesn't provide as much noise shielding as the original asbestos cladding did, and so we've had a consequential increase in complaints about noise because of the new cladding. So you kind of solve one problem and end up creating another. Thanks to life.
Yeah. Yeah, thanks for that. Just a couple of questions on your evidence, Carmen. Return to your paragraph 5.14. This is in relation to EFP2.
Yes, yep.
Now you've suggested some amendments to 3.
Yes.
But the phrase including phasing out existing domestic solid fuel burning appliances is still, you're saying that should still be there. Do you think that could be interpreted to include existing compliant or, you know, low emission, ultra low emission burners as well?
It could. I understand through attendance of the pre-hearing the drivers in terms of some communities in Otago who don't comply with the current PM standards under the NES and the aspirations to put more controls in place in some of those problematic areas in Otago.
I suppose when I come in and read it without that background, I read that and
it is in the context of polluted air sheds.
Yeah, understanding that. But is it, and I suppose, you know, we haven't heard from the Section 42A officer yet, so you've submitted here, so I'm questioning you if you've been through the pre-hearings and the like, but so would the intention be that even if there are compliant low emission burners, that they are phased out?
I wouldn't like to prejudge that outcome.
Well, I say of the 42A officer, and I know this is slightly outside of probably Ravensdown's key interest there, but it's probably in their interest getting issues within the limits. Let's see if I've got. I was just interested in relation to EFP5, and this is turning to the top of page 16. This is paragraph 5.23. D. Top of page 18. I'm just interested in your view as to, I suppose, what that policy's for.
So I haven't for the whole policy.
No, appreciating that.
Was it 5? Yeah. So the Section 42A report in the subparts talks about a list of activities which are included but not included, you know, including but not limited to.
Yeah, and I did sort of think, well, you know, large scale burners associated with, you know, the ones that aren't associated with industrial and trade activities, and people can consider, you know, hospitals or.
It could be more inclusive. I was primarily looking at it and from Ravensdown perspective about primary production activities, fertilizer application and industrial and trade activities. So that all applies to them. But my concern was the SHEPO just didn't make sense to me, and that's where my amendment comes from.
Yeah. I mean, do you think,
But you could just,
do you think that it's a beneficial policy to have in there, I suppose, is my question.
in the context of the remaining other policies, so we have two that are about ambient air quality, P1 and P2, managing ambient air quality, and then you have more directive policies, P3 to P6, that relate to managing discharges to air as I read them, and P3 is providing for, P4 is currently drafted is about avoiding, which I oppose. And then it's P5 is about managing certain discharges. And P6 is about impacts on mana whenua values. P5, in terms of the activities listed at the moment, are ones that could be considered to have the potential to have nuisance effects. So that's why it's listed. Those 5, I presume, are listed. You don't necessarily need to include those there. You could stop at the end of activities in the chapeau. I just see that list as a bit of a descriptor.
Yeah, no, I agree, and it's, I mean, it's not limited, it's, I suppose I just look at that and kind of think,
Too much.
does it too much? Yeah. Manage the adverse effects. Yeah. As a decision making, you're not going to get a lot of guidance for a plan out of a policy. Like
But
that, but
yeah, it can inform regional plans and
yeah.
rules.
You know, that's it. That's all I had. Thank you very much.
Thank you. Morning. Taylor, normally I see you acting for Fonterra. I guess because Bianca was talking about I'll carry on with the thing. And my mind's not really in it because we haven't been talking about it too much. But if I go to your paragraph 519, and I think you're recommending a change here to policy ERP1, which is the ambient air quality issue. So that's the air sheets, I guess. I'm wondering how that works when you say that air quality as a minimum is maintained where the standards are complied with, but then you allow discharges to go up to a limit. So you maintain, to me, say, well, it's at maybe 3/4 of the limit, so we have to maintain it there. That's what maintain sort of, although you're putting maintain in the context of the limit.
So you got
Just the way it phrases.
Yeah.
Confusing me.
you've got an ambient air shed, it's not polluted, it's complying with the standards.
Yeah.
So working with what was notified as P1 and all the recommendations and how that was had two elements to the policy. I endeavoured to rephrase that in a manner that worked for me, whereby you restated that if air quality is good, make sure that the air quality, ambient air quality, is managed to maintain the air quality. And that part of doing that is by allowing discharges, provided it doesn't degrade the air quality below the standard.
Yeah, so it's maintaining air quality as opposed to maintaining it at its current level, it's maintaining it.
Maintaining the good air quality, above the standards.
There has been concern raised that this sort of steps beyond what the regulations, well, not this, but the approach is a bit more stringent than the air regulations. So it was one of those concerns.
Yeah, I had a number of concerns with these objectives and policies in the air chapter and tried to reframe them in terms of what I see as practice in the context of the NZ air quality standard.
Your objective here too, I think, which you deal with on page 17. Your recommendation, I think you've changed adverse to localised, but the word protect is still in there. In the related policies is down below, provide for managers and provide for managed discharges, provided those things are not adversely affected. We have had people say, well, we can't always protect, for example, amenity values. Sometimes there's going to be an impact on them. Is that a concern to you at all? Because I noticed down in year P4, your instruction there still keeps offensive and objectionable with not just and dangerous, and I kind of see those two things as different. You have an amenity sort of effect, but then a sort of a health effect. Whereas I think there have been some recommendations that have come through, or evidence that we should be separating those. We should be focusing on perhaps avoiding the noxious and dangerous effects, and then just manage other effects that which are generally falling within those amenity sort of related offences and objectionable to the standards.
I am willing to defer to other experts, but my understanding.
I'm not one of them, so that's why I'm asking.
My understanding was that offensive and objectionable sit at a level lower than amenity effects. It's like, this is bad, it's making me feel sick. It's, you know, it's sort of that level. It's not just the general amenity effects of discharges to air. So that's why it's important from my perspective to not cause those.
Yeah. So is it okay? So is there three sort of levels? You think so? Noxious and dangerous offences are objectable, and then there's the amenity related.
There's an air discharge. How do we manage those effects? You know, to make sure we're not seeing a smoke cloud or a little. Yeah.
Yeah, that hadn't come through to me in the submission, so that's interesting. Yeah, I have to think about that. Yeah. Okay, well, that's kind of all I had for you. I think that you're clarifying where you were getting your evidence there. But then I just had some questions around. I found evidence very interesting, and we just heard from Beef and Lamb about and effectively what they've said. That this actually may be an unfair question for you, so if you can't answer it, just say. I was going to say later off. Don't strike that from the record. Whoever's keeping the record. Basically, what they were saying is that effectively they are producing more meat with less stock and less of the best land around. And they didn't say this in context of that statement, but they said that it's a very low input business, and you're part of it as a fertiliser. I'm trying to, my way of thinking, to be able to achieve that, you've probably put more fertiliser on, but I might be wrong. I'm just wondering if, because they also say how low their carbon footprint is compared to the same industries around the world. Can you enlighten me on how that works? And because I'm guessing you guys are putting a lot of thought into how you manage fertiliser, and that's what comes through in the evidence and how that all works.
Yes, we are, and I was interested in that discussion that was happening this morning. And I'm not a farm systems expert, but my high level understanding of the way you can produce, more meat from fewer animals doesn't necessarily infer a greater level of, say, fertiliser input into the pasture. You can achieve that with genetics and a sort of a better class of animal, or a more higher producing class of animal. So a lot of that is achieved by genetics. It can also be achieved by a higher input regime in terms of how those animals are fed. And again, that doesn't necessarily infer, it could infer a greater level of fertiliser input into a pasture-based system, but it could also be achieved through simply a different feed regime, whether it's different crops or different methods of feeding those animals. I think the other important thing in terms of my recollections of the discussion earlier was that inference that was just around it. I think it's important to also recognise that all food production, whether it's animal or plant-based, has an impact, requires inputs, has impacts on that surrounding environment. And I think in our discussion around food production, that's something that quite often doesn't necessarily get the emphasis that I think it perhaps should. Similarly, and this is something that Ms. Taylor and I were discussing earlier, is around the MPS for highly productive land goes some way to protecting that land for food production. It does not, my understanding in and of itself, enable the use of that land for food production. So it's that sort of ring fencing of the soils and protection of the soils, but doesn't necessarily, it requires at a more regional level that enabling of food production on that land.
Yeah, and that's always been one of the problems with that sort of approach, and we have that here in Dunedin. We have a lot of high class soil on the edge of the Torrey Plain. But the way food management distribution systems work, they no longer produce it there. So it's like, well, it's just going to sit there and graze. So yeah.
Back to your original question, and perhaps more specifically to some of the work that Ravensdown is investing heavily in, is around fertiliser products, fertiliser, just the actual aspects of, say, the production of the granule strength, all of those things, the precision placement of those granules, all towards an end where farmers can produce more with less fertiliser, which sounds like an oxymoron for a company that deals in fertiliser, but that is the future, to enable our farmers to maintain their levels of productivity whilst reducing the footprint that activity has on both the land and the freshwater receiving environment. And that can be achieved through choice of products, timing the right product, the right rate, making sure it gets in the right place in the first place. And pure economics, certainly currently, with the cost of fertiliser, no farmer is wanting to put on any more fertiliser than they absolutely have to, simply because of the cost. So there's been huge inroads, even in the time I've been at Ravensdown, advances around that technology, whether it's spreading, the way fertiliser is ordered, the way aerial spreading is being undertaken, coatings that are being put on fertiliser granules to reduce nitrous oxide discharges, so the nutrients that are in the expensive granule are actually available for plant uptake to be used by the plant and ultimately the animal that might be eating that plant, or the consumption of it. So yes, that will continue to be a key area of investment for Ravensdown.
It was quite a good story that came through that's not necessarily told. Sort of gives you some heart when we see the concerns that are raised, that these things are being addressed and almost can fit within, or probably can fit within, some of the more protection-based approach that we've got coming through here. Would you agree with that?
Yes, I would. And the other driver that I think is also driving behavioural change is what we're seeing coming through in legislation. And a key example of that is the recently introduced nitrogen fertiliser cap. And last year was the first year that dairy farmers were required to report that information. Ravensdown had a key involvement, along with our competitive balance of nutrients and a group of regional council representatives, to actually build the reporting portal for that information. And I think most councils are currently reviewing those reports that have come in, and it definitely is, driving that change, and actually the majority of farmers can work within that fertiliser.
Great, thank you. I actually just did have one more question for you, actually, Carmen. Sorry, and it was in relation to paragraph 4.9, objective 3 in the integrated management section. You would have heard the discussion around the definition of environment, etc. In that, the way that objective is expressed, it starts with Otago's communities, blah blah blah. Support and restore environmental integrity, which the Otago communities are a part of. Or is that phrased in a way that sort of removes the people of community from that definition, because it's kind of circular?
I read the objective that communities, people are placed first. And then it talks about the support and restoration of environmental integrity. And I read that as the natural environment because it then goes on to support the life supporting capacity of air, water, soil and ecosystems.
Yeah.
So I read that together.
That sounds probably meant to be read, just, yeah. Okay, thank you.
Source, let's call it that.
You may.
Oh. I just have a couple of issues I want to raise now. They're both within your summary, meaning under C and E. Summary. And C, my take is that this review is quite poignant in fact, in view of the fact that in a couple of years' time, you're having to renew or sort of a couple of your resource consents that the need works expire. Is there anything more you're able to divulge on that to us that you want to?
Certainly. And it's an interesting time to be confronted with a consent replacement program, given the pending, we're going to be caught in one of the first cabs of the rank, to use a casual expression, of the new legislation. And so we've just recently completed a review of essentially the pros and cons of whether we look to go early and have more certainty around a consenting framework, which may likely result in a shorter duration consent, but to try and put that application in ahead of the new legislation, it's unlikely we have that ship has effectively sailed. But this same site was consented in the early 1990s, and so was also subject to a change in legislation. And some of my colleagues down at the works remember a fairly torrid process at that time of consenting under new legislation, where there is virtually no case law, limited expertise, both within the organisation, but also the professional practitioners we rely on also finding their own way, the regulators finding their own way, and yet 30 odd years later, we find ourselves in the same situation. So we're confronted with a consenting framework at the moment that is unknown. So we're engaging our technical experts now to complete technical assessments that we hope, to the best of our knowledge, are going to be sufficient to enable us to apply for those resource consents come the day. We're really waiting on the National Planning Framework, which will hopefully give us a little bit more direction as to what we need to, what sort of scale of improvements and upgrades we need to look to be able to implement. And I think we're definitely looking at a pathway of adaptive management. But from a business operations perspective, whilst that framework needs to be adapted, it also needs to provide certainty for us as a business, so we can actually meet the commitments that we're promising in terms of committing funding and also resources and the technology needed to be able to commit to those upgrades. And we're looking at, we've got 3 manufacturing sites around New Zealand, and one of the key things that I look at is the construct of the consent conditions, and actually what works in terms of giving the local authority the assurance that we're going to operate within the parameters of those consent conditions. But actually from a business operations perspective, can we commit to what and so we don't end up over promising and under-delivering, because that's not a situation that we want to find ourselves in. So adaptive management is where we're heading, but with key steps, and the consent for our Dunedin works has had a condition that requires it's a 10-year technology review. There are other superphosphate manufacturing sites around the world, and it's really important that we look to both within New Zealand and offshore, say, well, what is current best practice? How can we apply that to our site here? What's feasible given the different operating constraints, but also, just the different sort of size and scale and intensity of those plants and the needs. So I hope that answers your question.
Thank you. My other question, I think you've partly addressed it, but not answered it, relates to E in your summary, where you say Ravensdown supports a robust RORPS 2021. What do you mean by robust?
I think what I'm getting at there is clarity, so direction of where we fit, and this was to Bianca's question earlier around that how big is our desire for special recognition. What we look for in a planning framework is where do we fit? And some of our operations, for instance, some of our bulk stores are in the rural environment, and we might have stormwater that we collect from those stores, and we might irrigate that to land, and then we get caught between, are we discharging an industrial stormwater from a site that's usually on the hail register, or are we a farming activity? And so there's that. We definitely don't fall between the cracks, but we can get caught between two sets of provisions that don't necessarily line up particularly nicely when it comes to what we're trying to achieve. So when I say robust, it's about seeking that clarity in the other planning documents that sit alongside or fall out of the regional policy statement of where do we fit, where's our pathway. That's what we're looking for.
And I did have one other just add on, and it's more out of curiosity than anything else, but at the end of that E, you referred to the ongoing use of the wharf at Ravensbourne. What's that about?
So now again, I'm hopefully going to tell you the right story. So just adjacent to our manufacturing site at Ravensbourne, there is a wharf, and we use that wharf for discharging products, but also bringing in raw materials for the manufacturing site that enables us to just move those products and materials straight into our manufacturing site, as opposed to having to unload at Port Chalmers and truck those materials to the site. And I'm not fully abreast of the history of the operation of the wharf. It is currently under repair and being repaired, but the business highly values its ability to operate, to be able to use that wharf.
You don't own it.
I can maybe add, it's owned by Porto Cargo, and Ravensdown has a lease to use it, and they're the only company people that use it.
Okay.
That's right.
Thank you very much.
Very said he was curious about something in your evidence, and so am I. The paragraph C, the manufacturer 110,000 tonnes of superphosphate and dispatch 160,000 tonnes of bulk product. What's the difference?
Not an error of mathematics. We manufacture superphosphate. We also bring in nitrogen containing products such as urea, diammonium phosphate, and other products which sort of move through the site as if it were a store. So we manufacture one line of products from raw materials into dispatched. Other products are brought in, manufactured and dispatched. Hence the discrepancy between the two numbers.
As Taylor, you used a technique of wording in a number of places of recommending that we change the word avoid to ensure that discharges do not. What's the difference? Well, is it are you suggesting that ensure that discharges do not carries with it a connotation of manage by conditions, whereas avoid is what it says, and as the Supreme Court says, it says just do not do.
It's it's more policy development consideration with the avoid inferring potentially prohibited activity status, even though you may have clarifiers on that, and I'll probably go to some of the provisions. I think that's where we
you look at EFP4, this is where I first picked it up. So your page, bottom of page 40, or again,
I think it will be later when I have my final recommendation.
Yeah, it was it
Page 17.
Page 17. Yeah.
Paragraph C.
So I just struggled with what really was the difference to anybody reading it in the normal sense. Ensure discharges where do not cause.
To me,
differ from avoid.
To me, the reading of the policies is P4 is recommended. It's avoid discharges to air. So, and then the rest of the policy follows, but you're avoiding the discharge. So therefore you shouldn't allow them. You shouldn't have a regulatory pathway for them. Whereas my interpretation by rephrasing to ensure discharges. It doesn't restrict having a consent pathway for discharges. But in doing, if you have a consent pathway, you make sure that they do not give rise to those effects.
Wouldn't it be more straightforward to suggest phraseology like manage discharges to air so they do not?
I'm more than comfortable with that.
And just above that, while we're on page 17, yes, the recommendation effective objective O2, and just to keep it's already touched on it a bit, but just from a slightly different angle. How does one work out what are localized effects?
So this goes back to two objectives being read together, and that as notified, and even as they currently stand, they don't necessarily distinguish between O1 being about the management of ambient air quality in air sheds and O2 being about discharges to air and managing discharges to air. And so I was trying to capture, and it was as a result of a discussion during pre-hearings, capturing that the intent of that policy, while aiming to protect those values listed, really related to the discharges to the air and the fact that they can have a more localized effect versus an air shed effect.
So I'm not quite sure that I'm with you. It just that last part of what you just said seemed much the same to me. And what is the difference between an air shed and
ambient
localized effect?
The air sheds are generally quite large and have a lot of activities occurring within them. So you're managing the activities within the air shed whole more holistically, whereas this I read O2 is relating to a site-specific discharge. So therefore you have a localized, potential localized adverse effect for a site-specific discharge. I am aware that other parties have done various other formulations reflecting the same concern I had, and I'm generally comfortable with their recommendations as well for the rephrasing of that.
Thank you. I'm jumping around a bit here, I'm afraid, but can I take you back to your page 9, 5.9? Again, it's probably repeated later, but when you were discussing EFP1, you talked about, and I know this is in the notified version, this type of wording appears as well, but ensuring discharges to air comply with, shouldn't it be national air quality standards?
So there are the national environmental standards for air quality, and they're the standards that people use. There are also a number of guidelines that experts rely on. So this was the original submission. In terms of my recommended changes, and I think I moved away from that by the time I've got through to my final recommendations.
Take me to that.
Just going to find it.
Page 11. Yeah, yes. Yep, top page 11.
No, that's Council's Officer. Mine is 519
Sorry,
on page 13.
Yeah. Yeah. It was what I was about to go on to ask you about was the four guidelines. Are they defined? I can't recall, but how does one know what they are?
In this context, you're generally relying on the air quality experts, and they pull it in, so it's not defined in the RPS. I would be more than happy to stop at the air quality standards if that was provide more clarity.
those are all my questions. So thank you both very much. Very clear evidence and very helpful.
Thank you.
Thank you.
Bring this for anyway.
No, she's excused.
Well, how are you? Right, thank you. We've discovered that we can only see you really on the big screen once you actually speak. So,
I can see myself on the big screen right behind you. It's a little bit disconcerting.
right. We're in your hands. Thank you.
Okay, thank you. Look, I'm appearing today for Transpower as well as for New Zealand carbon farming. I can go in either order if there's anything that New Zealand carbon farming is probably very, very short and sweet if you just deal with that first.
Right. Yes.
Okay, thank you. I filed some rebuttal evidence for New Zealand carbon farming, and it was generally supporting the evidence that you heard, I think last week, from Ms. van der Spek from Waitaki District Council. My evidence supported her position that there is no need to define permanent forestry or carbon farming or any definition in the Otago RPS. She gave evidence in relation to some of the things that are happening at a national level in terms of the reviews of the national direction for production and permanent forestry, and alluded to the fact that it's probably best dealt with at the national level with any necessary policy responses happening in response to that. I support her position, and I don't know that there's any disagreement between in relation to any other evidence or parties. Perhaps the only other thing to note is that the necessity for any definition probably ought to be tested as well in relation to whether there are provisions in the RPS at all that refer to permanent or carbon forestry that would necessitate a definition at all. And my client can't join you today, but I'm happy to take any questions, and also in relation to the way their business works, if you have any.
Yeah. Oh, no, I don't have any questions of you, Ainsley, just to possibly note that maybe you're telling Victoria off a bit in your evidence about prejudice discussions.
Yes, well, that might be true. The conversations around the definition probably involved a number of parties that didn't have submissions in relation to the topic, so the conversations were interesting.
Okay, thank you.
No, and I have no issues in that regard. Thank you.
Are you ready to turn to Transpower now?
Thank you.
Okay, thank you so much. I'm covering 4 appearances and 1 appearance here, which hopefully is more efficient for everyone. The legal submissions from Ms. Scott set out the parts of my evidence that are relevant to week 1 and week 2's hearings. We've already traversed mana whenua and mana whenua issues in the first hearing, the first week. And at 4.6 of her legal submissions, she sets out the other parts of my evidence that are relevant to today. I thought one of the most efficient ways to perhaps work through these matters is to turn to Appendix A of my evidence that sets out any further amendments that I've suggested and supported in my evidence to the Section 42A version of the proposed RPS. And at page 1, unfortunately, I don't have page numbers on it, dealing with cross-boundary matters in part 1, I just suggest one further amendment to that in bullet point 3 to refer to both the management of natural and physical resources across boundaries. Now, this is important because, of course, the national grid is a physical resource. And I think I don't need to say a whole lot more here in relation to cross-boundary matters, but you'll pick up the theme through my evidence that I've really suggested that there's been quite an emphasis on natural resources, perhaps at the expense of physical resources. my evidence is suggesting that there needs to be a little bit more consideration of issues in relation to physical resources through part 1 in the significant resource management issues for the region. Turning to the definitions, interpretation chapter, there's I only suggest one further amendment on top of what the amendments that have been made in the Section 42A report, and that's in relation to the definition of nationally significant infrastructure. Now, in my evidence, this is really of no consequence to Transpower, but I would suggest that reference to gas pipelines in the North Island isn't necessary in the context of Otago, and certainly I don't think there's any need for the RPS to firmly adhere to the MPSUD to refer to things that are patently not relevant to Otago. If we turn to the significant resource management issues for the region, my evidence probably deals with a couple of themes. The first being reference to physical resources. Now, I think there's been, as I've just mentioned, an overemphasis on natural resources at the expense perhaps of physical resources, and I've suggested some amendments to the introductory text that I think better align to the role of the Regional Council, the purpose of the Act, and the direction given in the Act to what an RPS needs to do. And the other thing that I suggest in my evidence is that there is a strong need for a significant resource management issue for infrastructure. Now, Transpower's submission sought a national grid specific issue, if you like, but my evidence suggests that that can be broader and could address infrastructure in a more general sense. Of course, the national grid is a matter of national, or the need for the national grid is a matter of national significance. So my evidence is that if it's a nationally significant matter, then it must be regionally important too, particularly given the number of assets that Transpower has and the need to transmit electricity within Otago. I've given a lot of thought, and there have been a number of discussions between parties in relation to the what an infrastructure issue might look like, and I've suggested in my evidence that a really good starting point would be the New Zealand Infrastructure Strategy. Now, that document has been prepared by the Infrastructure Commission, and it was prepared with significant amount of research. It's also included consultation internationally and nationally, and public consultation and feedback as well. So it's a relatively robust document that really deals with the issues facing infrastructure, puts them into context and suggests some challenges and ways forward to deal with those issues. And it may be a really good place to start with an Otago lens to work on an issue that addresses the importance of infrastructure to the Otago region. And perhaps the last matter I really deal with is integrated management. And the majority of my evidence here really deals with how some of the integrated management approaches suggested are perhaps taking direction given in higher order documents for confined matters, for instance, for coastal matters or freshwater matters, and applying those concepts in a more broad sense. And also applying draft legislation concepts in a broader in any sense at all. What I've expressed in my evidence is some caution around the way in which that's done, and suggested that particular circumstances and around, for instance, applying environmental limits or whatever term that sets some hard boundary. I think the terms that's used. I think there needs to be a lot of care when you take a concept that's, for instance, for freshwater, or a concept that's expressed in the New Zealand Coastal Policy Statement in relation to, say, the precautionary approach. I think there needs to be a lot of caution when you take that approach that's been applied in a specific way in a higher order document to the coastal environment, to apply it more broadly or use the same expression to apply to resources beyond, say, the coastal environment in that case. I've suggested a number of amendments and also suggested where this comes up in other places in the regional policy statement that there just needs to be care. I'm not suggesting that there ought not be capacities or limits or things like that in all cases. I don't think that it ought to be undefined, that there needs to be clear about where limits are and aren't appropriate, or where a precautionary approach is and isn't appropriate. For instance, for hazards, I've agreed in my evidence that would be appropriate in that case. That's all I've really got on these topics as a real quick summary of what my evidence says. I know that you've read it, and perhaps I'll just repeat my direction to you to perhaps look at the red amendments in attachment A to my evidence, where I've suggested further amendments to the section 42A version.
Thank you, Ms. McLeod. So you're available for questions now.
Yes, thank you.
Yeah, thank you. Now, I did have a couple of questions, but just checking, I'm pretty sure you've covered them off in what you've just addressed us on, which has been very helpful. So
that's good.
For that.
Thank you. Afternoon, Ainsley. I don't know if you've been listening to us on YouTube. It sounds like a lot of people have been, which is kind of disconcerting, actually. They know what we've been talking about the previous day, but we've had a lot of conversations around the exact issues that you've raised. Firstly, the lack of recognition of the, I guess, the physical side of the environment and the economic and social wellbeing, etc., that flows from that, and also on the integrated management process, the priority issue, and we've had both sides of the spectrum there, I guess. But I can't recall, but I think you may have been involved in discussions with the telecom companies around a general infrastructure issue that they've promoted by Chris Warner, I think it was.
Yep.
Have you considered that? And is it, because I understand the actual electricity distribution companies were, and it might have been more of a timing thing, I think they indicated, so they didn't get really a chance to address it in their evidence, but they seem to think they had slightly different issues that may not fit within that generic one. So I was wondering whether you had any thoughts around that.
Yeah, yes, I was aware of the drafting, and I have seen Chris Horn's evidence and am aware of that proposed drafting. My view is that some of his drafting is a little bit focused on problems or issues that are current, whereas my express preference and my evidence was to look at some of the clues that we have in New Zealand infrastructure strategy about the issues that we face at a broader level going forward around carbon, for Transpower, carbon zero. New Zealand is going to be a very, very important part of the challenges Transpower faces in operating, maintaining, upgrading and developing the national grid. So those are the kind of themes that I would suggest need to be woven through any issue around significant infrastructure in Otago.
I guess, yeah, okay. I don't think you've attached that strategy, have you, to your evidence, but I guess we can find that
Yeah, I've provided a hyperlink to it in my evidence. I can certainly send it through as a PDF if that's of assistance.
Yeah, well, it may be of assistance, but I guess sort of in that context, given you do have an NPS and your probably day-to-day planning operations are more controlled by district plans, is it such a big deal for Transpower? And related to that is the question around that priority, decision-making priority that's in there, and that's the argument we've been having, well, not argument, discussion around how that aligns with section 5. Is it so critical for Transpower? And I guess in the context of that policy too, I'm trying to understand what circumstances that may cause you a problem when you've got an NPS that's quite enabling.
Well, the NPS needs to be given effect to in the RPS. And the NPS isn't so enabling that says Transpower can go forth and do everything as a permitted activity. So Transpower will either need to seek designations or resource consents for any substantial work. It's hard to imagine anything Transpower would do that would be a major upgrade being able to be done without a designation or resource consent, and indeed regional resource consents too. And that would mean that those applications or notices of requirement would be tested against the provisions, not only of the NPS, but of the RPS and district plans. And that is why it's so critical that the NPS is given effect to properly in the lower order documents. And of course, we have some direction around the extent to which you have recourse to higher order documents as well. So,
yeah, I guess that probably based on my question really is how far do you have to go in an RPS for something like Transpower's infrastructure? Obviously, it's recognised there. It's the lower order documents that are really going to be critical to your.
Yes, and the lower order documents need to give effect to the RPS as well. We did a lot of work in the partially operative RPS to agree, or there's certainly an outcome where there's a national grid specific policy. And my experience is that that's often where these processes end up, because it's the best way and most succinct way for an RPS and indeed then a district plan to give effect to the NPS without perhaps some of the specific matters that relate to the national grid applying in a broader sense, in the same way that I've expressed my concern around, say, NPS FM matters applying to matters that aren't freshwater. So that's been the most succinct way in my experience that documents that are giving effect to the NPS have done so. It doesn't have to be that way, but it tends to evolve that way.
Yeah, okay.
Yeah. Does that help?
Yeah. And I'm not going to go into all our discussions we've had, but it's been quite involved. But the other issue you raised was around, I think, the precautionary approach and how that's dealt with. And we've been having conversations around that because I think the panel's actually looked at those policies and without the discussion starting, kind of considered that they probably lead to an adaptive management sort of policy when you have uncertainty around information and promoting a precautionary approach. What's your view around that, how useful that may be as a reference in those policies?
Yeah, I certainly think there's a place for adaptive management type responses where there is some level of uncertainty. My evidence is that yes, there's a place for taking a precautionary approach, and similarly there is a place for an adaptive management approach, but it's about saying where that place is, and rather than just generally saying, casting it too wide, if you like.
Yeah, so that's kind of the sense I got from Mr. French from BCC, that it probably should be focused at a regional or district plan level, that sort of approach.
Yeah, and I mean, the beauty of an RPS is that the RPS can direct that those plans consider where those approaches might be appropriate rather than them being so directly instructed to apply across the board.
Yeah. And sort of one last question around the issue that you've raised with policy IMP2. Have you gone back into the section 32 analysis around that particular policy? Because there has been some discussion around that. If you're applying that to all natural physical resources, that could be quite a mammoth task rather than it actually focusing on a particular issue.
So I'm just going back to my evidence on this. This is in relation to the approach to decision making.
Yeah.
Yeah.
The prioritisation of life supporting capacity over everything else if there's a conflict.
Yes. This is where in my evidence I've suggested that it's been that decision making priority. While I have read the section 32 on this, and I have read the 42A report on this. In my view, it tends to mirror and adopt the approach of the MPSFM, and my view is that it's probably not appropriate to do so.
Yeah, okay, so the section 32 does, I haven't gone back and looked at it yet. Yeah, because we've had a discussion around the MPS thing being specifically focused on a particular issue with a particular resource. So yes, it would address that. So having a section 32 that's adopted that and just widened it to all manner of things where there may not be an issue, that's the concern people have been raising. So I just wondered if that's reflected in section 32 that you're saying it's probably not.
In section 32 of the Act, or in the section 32 analysis?
In the
analysis.
Yeah.
Yeah, I certainly know I looked at it, but I probably it might be best put to the council officers.
No, that's all right. I was just asking that question because I know you were experienced around plan preparation and so forth. Okay, thank you for that. Just on the same issue of the prioritisation and policy 1 and 2 recommended, well, both notified and recommended in a different version. At the bottom of, I'm not sure if your pages are numbered, but at the bottom of your paragraph 7.20, and it'll be again in your appendix, you've just finished that, you've amended it in a way that I think doesn't recognise the contradiction that is contemplated by that notified policy. In other words, the contradiction contemplated was in a situation where the higher order provisions don't enable guidance as to a conflict between provisions within the RPS. Now, your amendment just seems to ignore that, because you just say where there is a conflict between provisions, consider the higher order documents, whereas actually what the policy is saying is in situations where the higher order documents don't give you any direction, this is the priority that you must apply. See the point I'm making?
Okay, yes, I understand your question. The intent of my amendment was to not take the MPS FM higher order document, a single one, and apply that, because that's what I think this is doing, and rather provide the breadth of consideration across the decision-making directions given in all higher order documents. But I take your point. You are correct that it was talking about resolving it where the higher order documents don't.
Right. Yeah. Okay. Just in terms of, you correct me if I'm wrong, but in terms of the sort of projects that Transpower are involved in and will be involved in terms of trying to meet the climate change imperative that the government's providing for regeneration, the adaptive management techniques really wouldn't have any application, I would imagine. I mean, you Transpower just basically have to get power from A to B. There's no way of doing that in any sort of staged sense to try and work out what the effects are.
No, not for a project as a whole, but if, for instance, there was some uncertainty about effects where Transpower needed to traverse a braided river, there may be adaptive management approaches that would assist in dealing with uncertain effects on the freshwater ecology or hydrology of the river. So more come down to particular elements of a Transpower project. They can become quite complex projects, not unlike state highway projects, I guess, where you could have significant earthworks. You may be within water bodies. You may traverse areas of indigenous vegetation or outstanding landscapes that all lend themselves to a significant amount of investigation and hard work on the part of effects assessments. Does that assist?
Yeah, yes, it does. Thank you. Just going back to that policy 1 and 2 issue again, just as you were speaking, then I was just thinking that are you going so far as to suggest that the prioritization that is recommended to us and that was in the notified form fails to give effect to the MPS on for the national grid?
Yes, the direction there for decision making differs substantially to the direction for decision making given in the MPS for electricity transmission.
So which particular clauses in that MPS should we be looking at in that regard?
So the MPS deals with the way in which you address adverse effects from policy 3 through to policy 9.
Right.
And it talks about constraints on the ability to manage effects. It talks about enabling some effects. It certainly doesn't. It sets out a different framework that really just is intended to acknowledge the fact that the national grid is nationally significant and effects of the national grid can't really be avoided or minor. And the preamble is quite clear about that, about the challenges the national grid faces in terms of being linear infrastructure that needs to be certain places that cannot have minor effects.
So can you turn it in front of you? Have you got that passage in front of you? Could you read that?
In the preamble to the MPS, now this is attached as attachment B to my evidence.
Oh, right. Thank you.
Yeah. So,
really taking us
so that talks about things, it says things like these facilities can create environmental effects of a local, regional and national scale. Some of these effects can be significant. The transmission network is an extensive and linear system which makes it important that there are consistent policy and regulatory approaches by local authorities. The technical, operational, security requirements associated with transmission network can limit the extent to which it is feasible to avoid or mitigate all adverse effects.
Thank you for that.
So there's more in there, but the preamble to me assists in understanding why the national grid has an NPS in the first place.
Yes, yeah. It's interesting further down the preamble, it's what you've made of well made, but if you look at the statement, however, the national policy statement is not meant to be a substitute for or prevail over the Act's statutory purpose.
Yes.
Or national test already in existence. Further, the national policy statement is subject to Part 2 of the Act.
Yes.
And
yes, that's true. It also is intended to achieve the purpose of the Act in the making of the national policy statement. Look, I think that those are, you're right to highlight those matters, and I anticipate, I can probably foreshadow that you'll have some legal submissions on these matters when we come to the energy infrastructure and transport hearings.
yeah. Look, thank you for that, and thank you for your evidence. I've got no further questions. Thank you. And
Thank you.
We'll see you, as you say, at the energy and infrastructure. Thank you.
Yes, no question. Probably in person, I'd suggest.
Right. Okay. Thank you.
Thank you.
Well, of course, yes, thank you. Mr. Robinson, is it? Mr. Robinson. Good afternoon. In your hands.
To come on. Will I wait for my colleague to come on before I start?
See your name up there.
Sarah,
It's not on. I am here, yes.
We can hear you, Ms. Hope, but we can't see you at the moment.
Let me just see if I can. Is that better?
That's better. Thank you. That's good. Very good.
Good afternoon. My name is Peter Robinson, and I'm here on behalf of Wakakatahi. I'm here with my planning colleague, Sarah Ho, will be online, and Sarah will discuss the planning aspects of the submission. My paper is primarily to give context to the Wakakatahi submission. I have taken it that the panel has read my submission.
Yes.
Wakakatahi is the New Zealand, Wakakatahi, the New Zealand Transport Agency, has a statutory role through the Land Transport Management Act, and we contribute directly to the movement of traffic throughout New Zealand. We're guided by the government through the GPS and have a director and get directive from the Ministry of Transport. Wakakatahi roles include management and maintenance of the state highway network and funding and support to local authorities. As detailed in the submission, it is noted that although Otago highway length is only 1,300 centre-line kilometres compared to the 9,400 local authority kilometres, we take up 62% of the traffic movements in vehicle kilometres travelled, of which about 10% of those are heavy vehicles. The highways therefore form a major link across Otago and externally to other regions. The highway links the strategic pathways to the West Coast, Canterbury and Southland. This makes them critical for communities and as a central line through the regions. The management and maintenance needs of the highway must reflect this critical role. I add further that all the materials needed to maintain must also be accessible and viable for use. The main link is subject to vulnerabilities and resilience issues, and these are managed to ensure the roads can remain open as much as possible. The highway is the backbone to the nation and as such is limited to a direct singular line of connection. Often there are no alternatives with the strength and resilience to replace it or take the highway traffic even temporarily. Through the highway system, the freight generated by industry and agriculture can be linked to airports, rail, and ports, as well as across the regions through heavy vehicle movements. Tourism and other major industries are facilitated by the state highway network. Many do not realise it, but actually the highway is one of the longest conduits for services as well, with power and communications through the rural areas, travelling the length of the country. It also establishes its importance and role in lifelines, where it is the main arterial link in the case of an emergency or an event across the country. The value of the infrastructure for Otago is around $1.1 billion investment in the 21 to 24 period of the NLTP, and this reflects the investment necessary to maintain a safe and efficient highway system. It's essential that the regional policy statement recognises, provides for and facilitates all the activities needed to keep the highways operational, including operational training changes driven by central government, for example, multimodal use and those sort of things which are coming more and more online. And I take on board what Ainsley said before, and she so eloquently put it, we are a linear asset which cannot have just minor events. So if there's any questions, or sort of just a brief key point statement.
That's good, thank you. And there may be questions. Yeah.
Yeah, thank you, Mr. Robinson. Now, I just had one question which follows on from discussions we've had, which you may be aware of with others around regionally significant infrastructure. And I did note that you've suggested a new objective around this, but I mean, if there was to be an issue, an additional issue added in, would you be expecting some recognition within that, or is your preference that I suppose the highway network is more sort of woven in throughout the document?
From the perspective of a user, because I'm an engineer who helps look after the highways. From the perspective of an engineer who looks after the highways, I would rather see it all interwoven so that you clearly have a path to follow to deal with what you've got to deal with. So long as it's clear what that pathway is. But Sarah's probably better equipped to answer that question.
Thanks.
No questions from me, thank you.
Just a couple of points, Mr. Robinson. I was intrigued at your, by the way, your figure numbers are all a bit astray, but can I take you to figure 2 on your page 13? And Katiki Beach, and is that armoured already? Is that in that photo? Have you got it in front of you?
Yes. So, yes, so that has been armoured under a resilience project,
right.
And it's expected to hold for any time, but the sea does gradually erode away that armament.
Right. So in that sort of setting, it is you gave the option of using the Hawke's Range Road alternative, which your photo was pretty descriptive of the difficulties of trying to have a state highway along there. But in that sort of setting, would Waka Kotahi, if need be, look at compulsory acquisition to try and shift the highway inland? I'm looking at your top photo and just my vague memory of driving down that stretch of road. And I'm from Marlborough, so I don't go there very often. But is it not an opportunity for just movement? And is that something that you do on occasion?
So on occasion we do, but we have to be linked with projects. So I've got a site actually in the Southland area where a recent heavy storm has created cracks in the road, but it's actually quite stable. We're monitoring it. But to be able to purchase the land, it's a farmland beside it, so to purchase and do a road deviation around it makes absolute sense. But until there's a project funded under resilience to actually do that, we can't anticipate. So in the past, we used to use designation as the way to go. This is where we would put the road if something happens and then work towards that.
Right.
Now that it's a little bit more of a path to get to that level of process.
So is that a difficulty that's caused through your funding mechanism?
Second, sorry.
That's a difficulty that arises out of your funding mechanism.
It's the process. Yeah, Lynn's has a process and we have a process, and that's how they tie together. But yes, it's all that was to highlight was that as a backbone asset, there is no alternatives. So we have to be able to maintain that backbone.
Yeah, no, I appreciate it as an example. Yeah. No, look, I found your evidence very informative, and thank you very much for the effort here that went into it. But I have no further questions. Thank you.
Thank you.
Ms. Ho.
Oh, great. Atamari, Commissioners. My name is Sarah Ho, and I'm a planner for Waka Kotahi. While I'm an employee of Waka Kotahi, Peter has just outlined his evidence in a corporate capacity, and I'm giving evidence today in my capacity as a planning expert. I'm just going to talk through just a couple of the key points that I've made in my evidence. Although firstly, I'll just point out in my evidence on page 3, paragraph 6.1, I've actually omitted the word further submissions. So it should actually say Waka Kotahi made 4 submissions and 28 further submissions. Mr. Robertson's evidence outlines the importance of Waka Kotahi infrastructure, which is nationally and regionally significant as a lifeline utility, its importance for the regional economy for freight and tourism, investment through the NRTP and connection for communities to goods and services. Under the RMA, transport infrastructure is a physical resource, and the integrated management chapter is relevant to Waka Kotahi to ensure that the management of issues relating to natural and physical resources are well integrated. Waka Kotahi's transport infrastructure crosses different jurisdictions, zones and boundaries, and traverses almost all environments, both urban and natural. And due to its linear nature, it's continuous and it has to connect together. It's not always possible to avoid sensitive natural environments, such as SNAs, coastal environments, wetlands, freshwater bodies, etc. As currently drafted, the IM chapter does not provide a clear consenting pathway for the operation, maintenance, upgrading, and new transport infrastructure for Waka Kotahi. The 2 main provisions, which I will just mention that in my evidence, the IM05, where Waka Kotahi supported a submission by Fonterra to provide a new objective for regionally significant industry and infrastructure. Waka Kotahi supports this as it would add clarity that regionally and nationally significant infrastructure is appropriately recognised and provided for. The other main policy is the IMP1, which I have put in my evidence is a combination of IMP1 and IMP2, is that the decision priorities go beyond Part 2 of the Act, and this presents issues for Waka Kotahi where the natural environment and health needs of people are considered first. In my evidence, I provided examples of where this policy could be applied, and this may result in consents for Wakakotahi transport infrastructure potentially being declined, which obviously provides a risk to us. So I guess my evidence is really highlighting the fact that we think that, or I think that regionally significant infrastructure should be appropriately recognised and provided for. I'm happy to take any questions.
Thank you.
Yeah, thank you very much for your evidence. Now, see, we've had a number of different submissions from different industries proposing different approaches to how to, I suppose, better acknowledge regionally significant industry and its role in the region through the RPS. You're supporting Fonterra's approach for an additional objective in the IM chapter. We've had others who are wanting a new issue in the issues chapter or strengthening of some of the existing issues. I mean, I suppose I'm just curious as to why you think the best place for this is actually in the integrated management chapter.
I think it really comes down to, when you look at the integrated management chapter, that this is considered across the region as a whole. So it's always going to be considered, and that due to, I think, the types of infrastructure which Wakakotahi is responsible for, it is somewhat unique in that it cannot always meet all the provisions of an RPS or likely a regional plan or district plan. And when you are presented with objectives and policies which have different directives, and they are brought together under an integrated management theme where everything is to be considered and balanced and integrated together, it is helpful that there is some direction that that this type of infrastructure has been considered for the region and is considered regionally important enough to be considered as a policy or an objective in its own right.
Okay, and I can see, you know, it's important to the importance to the region, potentially an issue, but I suppose I look at the integrated management chapter as being more about how to manage the natural and physical resources of Otago in an integrated way. And I suppose the question is more, why is it appropriate to single out certain industries and certain activities in a chapter about integrated management?
I think because when you try to integrate, I think that's the balance between natural and physical resources, is that you cannot always meet particular, I think, requirements, I would say, for you know, the natural environment, which significant infrastructure in this case would often go through, even though there would normally be processes which seek to, you know, avoid or minimize those particular areas. Sometimes it is just impossible to do so. And I think when you would look at all these policies on balance, that the IM chapter is the one that you would go to decide which ones take priority or not. And if it's not considered in an integrated enough way, then I do not think that necessarily there is a great certainty that regional infrastructure can be provided for. Unlike Transpower, we don't have a national policy statement for transport. We rely upon the objectives and policies in the regional plans and regional policy statements and plans and district plans.
Thank you.
Oh, thank you, Sarah. I don't really have too many questions for you at all. So Bianca's kind of highlighted the issue that I sort of identified that you're focusing on we are having a hearing on integrated management, but along that thinking that you're talking about, it needs to be recognised in that section. I think Bianca was alluding to the fact a number of regionally significant providers and industries have promoted a new significant issue section, which actually recognises it up front before you get into the IM section. Would NZTA be interested in something like that, or being a part of any process that may come up with something like that?
Yes, I think we would.
Then would that probably go some way towards because I understand what your concern is. There seems to be a lack. What you're saying is a lack of balance in terms of recognising physical resources as opposed to natural resources, and the physical resources provide for our well-being. So there needs to be some recognition of that. I guess what other people are saying is that really should be upfront in the issue sections, and then everything flows from that.
Yes, but naturally, I think that you would still be referring to the actual objectives and policies, although that it is recognised through an issue. The issues are therefore what then transpires into your objectives and policies. But yes, I would be very interested in being involved with that.
Okay, thank you.
I think, Ms. Ho, that you probably get the benefit of being one of the last ones in the few days, and we've been thrashing these issues around that you've addressed. And your comments are in accord with a number of comments made by other planning consultants. So I don't wish to repeat those exchanges. I thank you for the clarity with which you've expressed yourself and on these issues. And the questions that have been posed to you by Bianca Sullivan and by Ellen Cubitt cover off the matters that I wanted you to respond on. So I don't need to ask any more questions. So thank you.
Thank you.
Yeah. Thank you, Mr. Robinson. So that concludes your presentation for today.
Thank you very much.
Thank you.
Ah, thank you.
Early day for you.
I know, it's early for all of us, I think.
We're going to see you again, no doubt.
Yes, just once in the coastal chapter. Thank you.
Thank you very much. All the best.
I can just make one comment. You've asked, your question did ask about the compulsory acquisition within the Public Works Act.
Yeah.
That still sits there, but we seldom use it. We tend to pick alignments and which have the least impact on people on the environment. So it is still there, but we seldom use it.
No, I resent that because I was aware that which is policy, but and it's nice to hear that it's still being adhered to. So we prefer agreements and voluntary arrangements. Excellent. Thank you. Well, that does wind up our day. Thank you. Apart from going home and reading more.
Yeah, that's